Zunaid, there's a key pillar in the waiting room.
I've admitted him, Justice Taron. We are live now as well. Thank you.
Are we set, my sister?
Yes, we are, Chief Justice. I will hand over to the clerk registrar.
Thank you, Mafidi.
Good morning. I am the clerk registrar for this hearing. Chief Justice and Justices of the Constitutional Court, all counsel are online. I call the matter of the residents of Industry House 5 Davis Street, New Dwarsfontein, Johannesburg, and others, and the Minister of Police and others for hearing. All counsel are invited to place themselves on record. Please note that this hearing is being recorded.
Thank you.
Chief Justice, members of the court, I appear together with my learned friends, Mr. Voss and Ms. Motlasedi, for the applicants.
Thank you, Mr. Wilson.
Chief Justice and other justices, I'm Advocate Mpaga SC. I'm appearing with my learned colleague, Ms. Pompo, and we're appearing for the 1st, 6th, 7th, and 10th respondents.
Thank you, Mr. Mpaga. Mr. Wilson.
Thank you, Chief Justice. At the outset, with my learned friend's leave, I've been asked to record that the respondents no longer oppose the application for leave to appeal. They obviously oppose the appeal still, but the issues relating to leave to appeal are no longer on the table between the parties.
Yes. And you're still ready to be interrupted from the beginning?
I'm still ready to be interrupted from the beginning, Chief Justice.
Thank you.
Chief Justice, members of the court, we submit that this application concerns what must count as one of the most egregious and systematic breaches of the rights to privacy and dignity in post-apartheid South Africa. The applicants are some 2,852 people. Over a period of 10 months, they were subjected to 20 police raids. They were roused from their homes.
Excuse me, Mr. Wilson. If you can just bear with me on a housekeeping issue.
Yes.
I would like to refer you to a notice of motion just to get clarity on what you seek. In your notice of motion at volume 10, page 988, you say you seek confirming para A of the order of the High Court, declaring section 13.7c of the SAPS Act unconstitutional and invalid.
Yes.
And if you go to para A of the order of the High Court, that's what it says.
Yes.
That is at same volume, page 1071, order D. I would like you to tell me what we should make of order D. Because if you read order D, it appears to me that what the High Court did was to declare part of that section to be unconstitutionally invalid and not the entire section. So if that is the case, what are you asking us to do when you say you want us to confirm para A of the High Court order?
Well, we agree that section 13.7c of the Police Services Act is unconstitutional, but the scope of its unconstitutionality is much broader, we submit, than what was appreciated or held by the High Court. And so what we would like the court to do is confirm the declaration of constitutional invalidity insofar as it went, and then extend the declaration to a broader set of subparagraphs of section 13.7. So we submit, and I'll take you to our reasons for saying so in a moment, but we submit that all searches authorized, all warrantless searches authorized in section 13.7c are unconstitutional. And for that reason, sections 13.7a and sections 13.7b are also unconstitutional because they have no purpose other than to authorize unconstitutional warrantless searches permitted by section 13.7c. The scope of the declaration of invalidity that the High Court made was limited to warrantless searches of the applicants' homes. Now, we submit that that failed to appreciate with respect the true scope of the right to privacy in Section 14 of the Constitution. In due course, Justice and Planter will take you to our submissions on the proper scope of Section 14 of the Constitution, and why, on an appreciation of the proper scope of the right to privacy, Section 30, all the searches that are authorized in terms of Section 13.7c ought to be declared constitutionally invalid, or at least the Section 13.7c ought to be declared constitutionally invalid because of all of the categories of search that it authorizes.
So you want a portion of that will be confirmation, and another portion will be the leave to appeal aspect.
That's
now
absolutely...
the question would be, why did you bypass the SCA? Because if you come to us, it's not leave to appeal proper, but application for direct leave to appeal. Yes.
So the primary submission on that is that we have regard first to Section 172(1)(d) of the Constitution, which entitles any party to apply directly or appeal directly to the Constitutional Court to vary or confirm an order for constitutional invalidity. So we would submit in this case, what we want in relation to the constitutional invalidity order is a variation of what the High Court did. Section 172(1)(d) of the Constitution, we submit, entitles us to at least approach the court directly. And the use of the words apply or appeal directly to this court is a strong suggestion that the Constitution envisages, in our view, that a variation of an order declaring a statute constitutionally invalid is something that properly forms the subject of a direct appeal. Now, we accept, Justice and Planter, that we still have to demonstrate to you that it is in the interest of justice for you to entertain a direct appeal. And we simply say this, that it would not be in the interest of justice if we are able to approach the Constitutional Court directly on confirmation and on variation of that confirmation order. It would not respectfully be in the interest of justice to make us then sever those issues from the High Court's judgment and pursue the other issues that we raise in relation to the interdict and constitutional damages in the Supreme Court of Appeal. Justice and Planter, you will have noticed from the judgment of the High Court, the relief granted by the High Court was interlinked. So the reasons, for example, for refusing the interdict, even though all the requirements have been met, were linked to the scope of the Declaration of Constitutional Invalidity. Now, if it's appropriate, and we submit it is, for us to come directly to the Constitutional Court for confirmation or variation, then it would be inappropriate with respect to separate the scope of the confirmation and the variation from the issue of whether or not, for example, we're entitled to an interdict. Precisely because the High Court decided those issues on a range of facts and arguments that were fundamentally interlinked. The second reason we submit that it's in the interests of justice to approach the court directly is that on the issues of interdicts and constitutional damages, the Supreme Court of Appeal has already had a great deal to say. You will notice from our heads of argument, Justice and Planter, that we are heavily reliant on a series of Supreme Court of Appeal decisions about when, if ever, there's a discretion to refuse a final interdict where the requirements of one have been met. And we've also relied on a number of Supreme Court of Appeal decisions that deal with constitutional damages. Now, those decisions in our submission are sometimes in conflict with each other. There's the decision in Comapi, which seems to suggest that constitutional damages can't be claimed for non-financial loss, and the decision in Kati that seems to suggest that they can. And so for that reason too, we submit that there's a wealth of Supreme Court of Appeal jurisprudence on which this court can draw to decide all of the issues raised in this application. That all of the issues raised in this application are respectfully interlinked. And they're all linked to an issue that is regularly, properly the subject of an application for direct leave to appeal. and that is the conformational variation of a declaration of constitutional invalidity. So if I was setting out the undisputed facts on the record of the circumstances of the raids. The applicants were roused from their homes on one occasion at 10 to 3 in the morning and ordered to stand outside. The police, immigration officials, and metropolitan police officers broke down their doors, rifled through their goods, and stole many of their possessions. One object of the police raids appeared to be the arrest and detention of illegal immigrants. But we know that the police also arrested anyone that they said looked too dark to be South African. A man who was too slow to respond to the police knocking at his door was slapped in the face and marched outside in his underwear. A woman who wanted to change out of her nightdress was forced to do so while a Johannesburg Metropolitan Police officer watched her. A few undocumented migrants were arrested, but they were later released in almost all cases. But as the High Court accepted, there was no evidence of any illegality found during the raids. Now, that means that the net effect of the raids in this case was never to combat crime. It was always to terrorize the applicants and the public at large. And what is more, Chief Justice, is that this is a summary of undisputed facts on the record. None of the facts on the record or found by the High Court are in any way challenged or disputed in this court. We submit that that's relevant for two reasons. First of all, the absence of undisputed facts again goes to the applicant's case on direct appeal. The court won't ordinarily entertain any application for leave to appeal if it involves the resolution of factual disputes. Of course, in this case, there are no factual disputes because almost none of the facts contained in the founding affidavit have actually been placed in dispute by the respondents. The second reason is that it gives the court a clear-cut, and we would submit quite staggering, set of facts about how the police, the city of Johannesburg, and the Department for Home Affairs have treated the poorest and most vulnerable people in our society. This is what Section 13.7 of the South African Police Services Act has permitted. And that has to be relevant to any interpretation of the scope and application of its terms. And what Section 13.7 has permitted is stark, unacceptable, and respectfully makes us wonder what happened to the constitutional promise of dignity and privacy for the applicants in this case. But we accept, Chief Justice, that this case is about the constitutional validity of the law that allowed the abuses to be carried out, and the nature of the relief to which the applicants are entitled. What everybody now accepts was a systematic, far-reaching, and egregious breach of the applicants' rights. The court will have noticed from the record that the High Court issued a declarator that each and every one of the applicants' rights to privacy and dignity had been breached by the raids. And it also reviewed and set aside all of the decisions to issue the authorizations to carry the raids out. Those orders, again, are not appealed against in this court. So you can accept from the outset that all of the applicants' rights were breached, and that the justifications offered in the review for the raids are not legally admissible and certainly not something that could have justified what happened. We're going to address, with your leave, Chief Justice, 3 issues in our oral submissions. The first issue concerns the constitutional validity of Section 13.7. The second issue concerns the applicant's entitlement to an interdict to restrain future searches of their homes. And the third issue concerns the applicant's entitlement to constitutional damages for the breach of their rights to dignity and privacy. I was going to address you on the interests of justice and leave to appeal. I won't do that now, subject to questions from the court. First of all, because Mr. Mpanga has indicated that the application for leave to appeal is no longer opposed. And secondly, I've encapsulated our submissions on that in my answer to Justice Mhlanhla's question anyway. So moving to the first issue, and that's what we say is the constitutional invalidity of Section 13.7 of the Police Services Act. We know that all but 2 of the 20 raids at issue in this case were carried out on authorizations issued under Section 13.7 of the Act. Now, Section 13.7 has 3 subsections. Broadly speaking, the first subsection empowers a national or provincial commissioner to issue an authorization to cordon an area off. That's subsection A. Subsection B sets out what the minimum requirements for that notice are. It must specify a period of no longer than 24 hours, must specify an object for the cordoning off operation, and it must set out the area to be cordoned off. Section 13.7c empowers any police officer that is in possession of that authorization to go into the cordoned off area at the relevant time and search any premises, person, receptacle, vehicle, or object of whatever nature without a warrant. Now, our primary submission is that the full range of those warrantless searches permitted in the circumstances of Section 13.7 are unconstitutional. And Section 13.7c is not just unconstitutional because it authorizes a warrantless search of a person's home. It is also unconstitutional because it authorizes warrantless searches of vehicles, receptacles, and people who happen to be in the cordoned off area. The High Court found, of course, that Section 13.7 was only unconstitutional to the extent that it authorized warrantless searches of a person's home, or their possessions, or themselves inside their home. And we submit with respect that the High Court mistakenly assumed that warrantless searches outside the home were constitutionally justifiable. This conclusion, we submit, was based on a failure to appreciate the true scope of the right to privacy in Section 14 of the Constitution. The difficulty for the High Court started, we submit, when it discussed this court's decision in Bernstein versus Bester. Of course, there's a very famous passage in Bernstein versus Bester that seeks to define the right to privacy as consisting of an inner sanctum that is then surrounded by concentric circles. The inner sanctum is the person and the home, and then there are concentric circles of expectations of privacy, which might include somebody's communications, their car, their relationships, personal information, and they move out from the inner sanctum. Now, the High Court, the gravamen of the High Court's decision on constitutionality was effectively that all Section 14 really protected was the inner sanctum, and that the scope of the right did not extend to the incidents in what Justice Ackerman, I believe it was, called the concentric circles. Now, we submit that that's wrong. We submit that Section 14 of the Constitution protects all of the concentric circles of the right of private life that were defined as such in Bernstein versus Bester. What Justice Ackerman said in Bernstein was that the considerations relating to the extent to which those incidents of the right to privacy could be limited were different. So obviously the considerations relating to whether or not you can have your home searched without a warrant are different to the considerations to whether or not you can have your vehicle searched without a warrant. But that doesn't mean that having your vehicle searched without a warrant, or that your vehicle or your body outside your home is not properly the subject of the right to privacy. And that, we submit, is where the High Court made its principal mistake. It assumed that where a police commissioner can point to a threat to public order and public safety, warrantless searches outside the home are not just permitted, but they are beneficial and important. That's a quote. The words beneficial and important are quoted from the High Court decision. Now, we submit that this is fundamentally mistaken. The right to privacy does not stop at a person's front door. As this court held in Hyundai at paragraph 16, when people are in their offices, their cars, or on their mobile phones, they have a right to be left alone by the state unless certain conditions are satisfied. Now, those conditions, we all know what those conditions are. Those conditions are that there is a law permitting an invasion of privacy and that the law is justified under Section 36 of the Constitution. Because the court failed to appreciate the High Court, failed to appreciate the scope of the right to privacy as extending beyond the home, the limitations analysis it conducted in its judgment was misconceived. What the High Court ought to have done is appreciated the full scope of the right to privacy as including one's body, for example, outside one's home. One has a right to step out into the street and not immediately be assailed by a warrantless search by a police officer, unless in terms of a justified limitation of the right to privacy. The High Court failed to appreciate that those incidents of the right to privacy were part of the right itself, and then subject the invasion of those incidents to a limitations analysis. What the High Court did was say, well, the right to privacy only really protects you against warrantless searches in your home. And we're going to subject that invasion, authorized by Section 13.7, to a limitations analysis. Now, the reason why we say that the right to privacy is much broader than the High Court found is that the text of Section 14 of the Constitution makes it clear. The default position under the text is that all police searches, body searches, searches of business premises, and searches of vehicles or private containers, bags, or belongings are forbidden unless justified by a law of general application under Section 36 of the Constitution. The words of the text of Section 14 is actually quite stark. It simply says, no searches of persons or property unless, well, it simply says everybody has a right not to be searched, not to have their person or their home or their property searched. That's where Section 14 leaves it. Now, of course, Section 14 can be limited, but if we're dealing with what the scope of the right is versus what the considerations for limitation of that right is, it's important to appreciate at the outset that searches generally are presumptively unconstitutional under Section 14. And for that's the reason why we say, Chief Justice, that the concentric circles of privacy referred to in Bernstein define the scope of the right to privacy, not a series of internal limitations. And that's what we submit with the utmost respect that the High Court got wrong. Assume the concentric circles were internal limitations, and they weren't, and they never have been. The inner sanctum at the center of those circles has the greatest level of protection, but the outer incidents of the right are also part of the right. It's just that they raise different considerations in a limitations analysis. So the starting point for considering the constitutional validity of Section 13.7 of the Police Services Act is accordingly to recognize that all the warrantless searches that it authorizes of persons, of premises, of persons inside and outside a home, of vehicles or receptacles of any nature, are infringements of the Section 14 right. They're limitations, and they require justification. We don't say they could never be justified. We just say that they require justification. And we know that in these particular raids, that the applicants' homes weren't the only things that were searched. We see on the record multiple reference to stop and search operations in cordoned off areas. So we know that it wasn't only the applicants' homes that were invaded, the police also went off and stopped people in public and conducted body searches, because that's what the record of the decision tells us, and that's what the minister's answering affidavit tells us. This is all important for one reason and one reason only. And that's the burden, and that is the fact. And again, this isn't, I don't understand this to be controversial. The fact that the burden of pleading and proving a justification for the limitation of a Section 14 right falls on the respondents in this case. And the primary basis on which we say that this court should strike down Section 13.7 in its entirety is that the respondents have made no serious attempt to discharge that burden. The respondents say two things, and only two things. The first is that warrantless searches make them more effective in fighting crime. And the second is that crime is very high. Now, we all know that claims of effectiveness and necessity have never been recognized as being sufficient on their own to justify a breach of constitutional rights. We also know, on the facts of this case, that the Section 13.7 power has been used to terrorize innocent people who are guilty of no crime, against whom not even a prima facie case has been made out. So what this court then sits with is a statute that authorizes a police commissioner to cordon off a large area and warrantlessly search anything in it, so long as a police officer, that commissioner, believes that it is reasonable to do so to preserve public safety or ensure public order. Now, on its face, Chief Justice, this is a breathtaking infringement of the right to privacy. Yes.
Can I just ask clarification from you?
Yes.
You are seeking this court to declare the whole of Section 13.7 unconstitutional. I'm going to just give you an example, and if you can just assist me where in the SAPS that kind of situation would be catered for. Police are being called, there's a huge crowd, and it is becoming uncontrollable and violent. And all that the police are being called to do is to cordon off an area. So the object is to cordon off an area and to protect the public and public order and safety. Is there a specific provision in the Act that deals with that? The reason I'm asking is that you saying that Section 13.7a cannot be read alone. It has to be read with Section 13.7c.
Yes. So if I can take the first question first, the closest that we've been able to find to such a power that you advert to, Justice Cheeky, in the Police Services Act is Section 13.11, which allows the police to cordon off an area where it is alleged an offence has been committed or an offence has been committed, and to control that area. They can stop people from getting in or out. In a crowd management situation, especially one that is supposed to have turned violent, it's inconceivable that there wouldn't at least be an allegation of criminality or that an offence had been committed. If there wasn't such an allegation, the cordoning off power would probably be improperly exercised because people have a right to gather. However, where there is...
Let's take, sorry to interrupt you. Let's take a protest. Let's take a protest, and someone calls and says that there are incidences of violence and properties are being destroyed and all of that.
Yes.
And so, there, the object would not be to conduct any form of search. It would be to control the crowd and make sure that there's public order and safety.
Yes, Justice Cheeky. We submit that can't be the purpose of the Section 13.7 power because it is the purpose of the Section 13.11 power. If there are allegations that offences are being committed in an area, under Section 13.11, the police have the right to cordon that area off and control access to it. There is nothing that Section 13.7 gives them on the example that you have posited to me, Justice Cheeky, that Section 13.11 doesn't give. That's our brief answer to that submission. Where there are allegations...
So your submission is that the control of the crowd would then fit into investigation of crime because Section 13.11 envisages that the area would be cordoned off for the purposes of investigation of a crime. And you are submitting that Section 13.11 then entails that situation or envisages that situation, the investigation of a crime.
That's absolutely correct. Where there has been not just an allegation of a mere protest, Justice Cheeky, but that the protest has ballooned up into something unlawful, violence or damage to property, there Section 1311 must be engaged. There is a second reason we submit why Section 1311 is the more appropriate power, and that is that Section 1311 is something that can be done by any police officer. The Section 1311 cordoning off power doesn't require an application to a police commissioner in the way that Section 13.7 does. So if on the example that you're positing to me, there's a large crowd in an area and prompt action needs to be taken to deal with members of that crowd who may be committing an offense or are suspected to have committed an offense, one would expect a very prompt response. Section 13.7 is inimical to that prompt response because one has to first apply to the provincial commissioner to exercise their powers under Section 13.7a. Then the provincial commissioner has to issue an authorization, and only then can you go and control the crowd. Section 13.11 is different. You can go and control the crowd straight away. So we submit that not only does Section 13.11 give the police the power they need to respond to the example that you put before me, Justice Cheeky, but that it's clearly the provision that they should use because it's the one that allows them to respond most quickly. A further submission we'd make, of course,
before you move to the further submission, the last submission you make seems to proceed from an assumption that a commissioner may not, where she or he deems it necessary, act with expedition.
Yes, but the question is how much expedition.
But must we as a court then get into that, any of that?
Well, no.
Make assumptions on how the police may or may not act.
That's certainly not what I'm asking the court to do. All I'm asking the court to do is compare the words of Section 13.7 with the words of Section 13.11. Section 13.11 entitles any police officer to cordon off an area where an offence has been committed or is alleged to have been committed. Section 13.7a requires a police commissioner to issue an authorization. It simply stands to reason that if there's an exigent situation, the Section 13.11 power, and the exigent situation is only to cordon off an area. The exigent situation only requires the response of cordoning off an area. It stands to reason that the more appropriate power in that instance would be Section 13.11 and not Section 13.7. We don't take the submission any further than that.
Yeah, I have difficulty understanding how 11 and 7A and B, or maybe let me just focus on A, cannot sit comfortably with each other. In the one, the police may only be concerned, as my sister Justice Chikri emphasized, the police may only be interested in the restoration of public order or ensuring the safety of the public, and not in the least at that moment concerned with the investigation of crime. And then under 11, the purpose or object may indeed be the investigation of crime. I just do not understand why the two cannot sit comfortably together.
They can't sit comfortably together, Justice Madlanger, because the purpose of the cordoning off operation authorized in Section 13.7a is to authorize the searches in Section 13.7c. So if Section 13.7 were merely a public order provision, it would read entirely differently. The searches wouldn't be authorized, for example. The police commissioner, remember, in terms of Section 13.7a, can only authorize a cordoning off. It's Section 13.7c that allows the implementation of that cordoning off. And
why is it that ineluctably there must be a search? If you read, and I'll take it in the middle, if you read C, it says, and may. where it is reasonably necessary. I read that to say there may or may not be a search. I don't understand it to say ineluctably there will be a search. I don't read it that way.
Yes.
So let me go back.
We don't attack.
Just a minute. Let me go back to A. I don't see why it is not possible for the police to restore public order, for the police to ensure the safety of the public without, of necessity, there being a search. I just don't see why it's ineluctable that there must be a search.
Well, Justice Madlanger, we don't attack Section 13.7a on the basis that it compels searches. We attack Section 13.7a on the basis that it authorizes searches. So we say that simply giving an ordinary police officer to the power to conduct a warrantless search of this breadth in this area over this time is itself unconstitutional. So there's nothing in our argument that requires a reading of Section 13.7 to compel police officers to search. It's giving the police the discretion. It's empowering the police that makes it unconstitutional.
And why do you say the search is authorized by A and not C?
Well, we say that the cordoning off operation is authorized by A.
Yes.
C authorizes the implementation of the cordoning off operation. Upon receipt of the written authorization referred to in paragraph A, any member may cordon off the area concerned or part thereof, full stop. Now, as I understand the point being put to me, is why can't the court sever everything that comes after the words part thereof in Section 13.7c? The question is, would that cure, sorry, I might be putting words into your mouth, Justice Madlanger, but I understand the question to be whether it would be appropriate to sever Section 13.7c after the words or part thereof.
How I see it is, C does see the possibility of the object specified in the authorization, which are the two things specified in A, being carried out without necessarily there being a search.
Well,
so whatever you excise, you need not, or you should not excise the object specified in A.
Well, Section 13.7c authorizes two things: a cordoning off operation and warrantless searches. All warrantless searches, we say, are unconstitutional, or granting authority to conduct those searches are unconstitutional. What is then left is the cordoning off to achieve the object set out in Section 13.7. But the question immediately arises, cordon off to what effect? The statute doesn't say. Section 13.11 does say, it says you can cordon off for this purpose, and you can control access to and egress from an area that is cordoned off. You strike out the warrantless search provisions of Section 13.7c, and you have an inchoate power to cordon off, and no power to do anything pursuant to that power. So at the textual level, we submit that the purpose
sorry, Mr. Wilson, I don't understand your submission when you say that it gives the power to simply cordon off. It says, in order to restore, let me read it. It says that in order to restore public order or to ensure the safety of the public. So it's not just cordoning off with no objective. The objective is stated exactly in Section 13.7a. It is to restore order and public safety.
Yes, sorry. I mean, I didn't mean to suggest that the cordon off power would not have a purpose. What I was saying, Justice Cheeky, is that it would have no effect, because the question is cordon off and then do what? Section 13.11 we submit says, and this is the interpretive argument, Section 13.11 says, cordon off for the purposes of dealing with an alleged offense or an actual offense, and then stop people from getting in and out of the area. Section 13.7 says cordon off and search if it's necessary. Now, if one reads these two at the textual level, and there's a purposive argument as well that I'll get to in a moment, but at the textual level, one would expect that Section 13.7c would specify what can be done in or around the cordoned off area. If the purpose wasn't simply to authorize what we say are unconstitutional searches, because that's exactly what Section 13.11 does. That textual analysis we submit is buttressed by a purposive reading of Section 13 as a whole. One wouldn't need, if one reads Section 13.7 purposively, one can see, precisely because there is no other thing that the police are empowered to do in a cordoned off area other than search people. One can see that the whole purpose of Section 13.7 is to authorize warrantless searches.
Mr. Wilson, I don't understand that. Cordon off and restore public order or ensure safety, the safety of the public. Please make me understand why you keep saying cordon off and then do what? Cordon off and restore public order or ensure the safety of the public.
Well, with respect, Justice Madlanger, that's not what Section 13.7c says. Section 13.7c says cordon off and search. The reading you're pressing on me is that one says that the police commissioner issues a notice in terms of Section 13.7a for a particular purpose. The police commissioner then, that authorization is then implemented. And other than searches, what the police are then entitled to do is anything that they think is necessary to achieve the object in Section 13.7a. That would make Section 13.7c much broader, not much narrower. It would enable the police to do all sorts of other things. One has to have a narrowly tailored power in Section 13.7c to make the section work. One can't just say to an ordinary police officer with respect, we think there's a threat to public order. Go and cordon this area off and do what's necessary to deal with that threat to public order. That imports a massive area of discretion on an ordinary police officer that we would submit is inappropriate. We would accept that it is perfectly acceptable that there could be a statute that says the police commissioner can authorize a cordoning off of an area. When that cordoning operation is implemented, the police may then, in that area, exercise a series of powers which are in themselves constitutional. What cannot be done is either the police commissioner can cordon off an area and send police in to conduct unconstitutional searches, or the police commissioner can cordon off an area because there's a threat to public safety and send the police in and allow them to do whatever they want or whatever they think is appropriate to address that threat. There must be guidelines in the legislation that set out what the police are supposed to do. Now, with respect, Justice Madlanger, they're there in Section 13.11. But other than warrantless searches, they're not there in Section 13.7. And that's why we submit that if one accepts that there is a public purpose to a cordoning off power beyond Section 13.7, then the proper thing to do would be to strike the whole of Section 13.7 down and allow Parliament to come up with that power and to narrowly circumscribe that power appropriately. Because at the moment, one simply can't read the section in the way that you suggest with respect, Justice Madlanger, because
Now, what do you make of the cross-referencing back to A in C?
Yes.
Says there may be a search if the A object cannot be achieved. What object? Because it seems to me that there may or there may not be a search. So if the A object is achievable without a search, that object must then still be achieved. What is that other than what is specifically referred to in A and B?
Our submission is at the level of no matter what the object stated in the Section 13A notice, the notice issued in terms of Section 13A. Authorizing warrantless searches to achieve that object by a police commissioner over a large area of potentially thousands of people has to be a breach of the right to privacy that requires justification.
That so I have no problem with. That's not the issue that my sister Justice Chikwe and I are debating with you.
Yes.
Debating with you is the ineluctable conjoined reading of A and C. That's what we are debating with you. Yes. Maybe we've debated it for quite a while now. Let me perhaps.
But Justice Madlanger, I'd like to understand the question, and it seems that I've misunderstood the question. So I understood the question to be a challenge to the proposition, or I understood the question to be based on the proposition that if an object was
is the dominoes effect, is the dominoes effect kind of argument, at least insofar as I understood it. I don't know if that's yes. how my sister understood it as well. The dominoes effect kind of argument, if C falls, then A must fall as well.
That is our argument, yes.
That is what we are trying to engage you on.
Yes. So that is our argument, and we say that there is no public purpose, that appropriate public purpose, that can be served by Section 13A without Section 13C as it stands.
Mr. Wilson?
Yes.
If we look at 13.7c.
Yes.
Upon receipt of the written authorization referred to in A,
yes.
a member may cordon off the area where it is reasonably necessary in order to achieve the object specified in the written authorization. The object yes. of the written authorization is that in any way linked to 7A.
Well, the object in the written authorization is something that the commissioner specifies in terms of Section 13.7b. So Section 13.7a is engaged where there's a need to restore public order or ensure the safety of the public. That's the broad category. Then Section 13.7b, Justice Theron, requires the commissioner to narrow down what that threat is and specify it. That didn't happen in this case, as we know, but for the purposes of interpreting the section, that doesn't matter. So then the object, which is ancillary to ensuring the safety of the public or restoring public order, has to be specified in the notice.
Would that make Section 7b and c somehow interlinked?
Certainly, that is our submission, Justice Theron. We also say that it's one of the things that interlinks A and B, because the notice that has to be issued in terms of Section 13.7a has to contain the object specified in Section 13.7b.
Yes.
And can I just make one?
We don't get that from 7a, Mr. Wilson. We get that from 7b. Object. The fact
yes.
Yes. Object we get from 7b. We don't get that from 7a. So so that in that way, A and B might not be linked, and A and C might not be linked, but there might be a link between B and C.
Textually, Justice Theron, I take the point that the object, the Section 13.7a is the bare power to issue the authorization to cordon off.
Yes.
But without B and C, the purpose of the cordoning off can't be specified, and the cordoning off can't actually be implemented because it's Section 13.7c that empowers an ordinary police officer to implement the operation. So the provincial commissioner can't, I mean, on the text of this statute, the provincial commissioner can't participate in a cordoning off operation at all. He can just authorize other people to do it. But I take the point that you make about the object, Justice Turon. I think that's correct. But I think there are other links between the three subsections that are inextricable in our submission.
Mr. Wilson, sorry, can I ask you, on a textual interpretation, can A and B ever be delinked? Because A is the written authorization and B is what is the proposed action. So it seems to me that they are inextricably linked.
Yes, Justice
A and B. And once B and C is linked, then it seems to me a complete linkage.
With respect, Justice Victor, that's our submission. The section 13.7a is the power to issue the notice or the authorization. Section 13.7b says what the authorization has to say. Now one wonders if section 13.7b is not complied with, is there even an authorization in terms of section 13.7a? Can there be an authorization in terms of section 13.7a that does not comply with the requirements set out in section 13.7b? And we would submit no, it can't. If I can just take, it might be relevant to the debate we're having for me to make this one further point. Section 13.7c says that on receipt of the written authorization referred to in paragraph 8, any member may cordon off the area concerned or part thereof, and may, comma, where it is reasonably necessary in order to achieve the object specified in the written authorization, comma, without warrant, comma, search. So what is linked, the empowering provision and the purpose of the cordoning off operation is clearly the search, not merely the cordoning off. And that's the interpretive, the textual interpretation I'm seeking to commend to the court, that the cordoning off and the searches are of a piece. One doesn't just draw lines around areas of the city for no purpose at all. That's effectively what Justice Cheeky put to me earlier. One draws lines around the city for the purposes of achieving an object. One achieves that object through the implementation of police powers. The police power granted by section 13.7c is inchoate without the warrantless searches. Now, if you accept that the warrantless searches are unconstitutional, then you must accept that the scheme of powers we submit that are set out in sections 13.7a, b, and c are also unconstitutional because that is precisely their purpose. Now, we do not submit that there could never be a...
Mr. Wilson, I'm sorry. If one were to adopt that interpretation, what would be the purpose of the permissive words where it may be necessary?
The purpose of those permissive words is to empower the possibility, but not to compel the necessity of searches. So the where it is reasonably necessary is a level of control over the empowering provision. So the purpose is to empower the police to do something, not to compel them to do it. It actually makes the section worse because it allows ordinary police officers a broad range of powers.
But that seems to agree with what was put, the proposition that was put to you by my brother Madlanga, that the purpose of restoring public order might still be achieved without searches. So if that is so, that means it is consistent with the permissive language of the section. If they were ought to search every time there have been a cutting off of the area, they had to search to reach the purpose of the section, then the permissive words don't make sense.
The object in the notice is one that is required, is one that requires the police to be empowered to search. It's the empowerment to search that achieves the object, not necessarily any particular search.
No, I'm sorry to interrupt you, but that cannot help us with the interpretation. We're trying to interpret whether the objects of section 13.7a might be obtained or achieved without the necessity to search. And the proposition that was put to you was that, yes, that can be. I follow the argument to say, but that's a dangerous situation because you allowing policemen to go and try to achieve that purpose without any guidance. I understand that, but I think it is based on an assumption. It is based on an assumption that police training does not skill them to know what to do in order to restore public order.
That's
yes.
not the point. The assumption goes a little bit further than that. It's not just a matter of police training. It's a matter of legislation being properly drawn to set out the circumstances under which powers to achieve the object in section 13.7a can be exercised. So I'm not casting any aspersions over the training of the police or the lack of it. The point is simply this, that where you empower the police over a very large area, thousands of people, maybe several square kilometers, to go into an area and do whatever they believe is necessary. That's not what the statute actually says, or it's not what the statute would say if warrantless searches were stricken from it. But to do what, if one interpreted it to say, to do what is ever is necessary to achieve the object in the notice, without any statutory guidance at all, I submit that this would be a wholly inappropriate piece of legislation.
Why should there be guidance in respect of people who are skilled? I would understand in respect of people who might not know how to go about exercising a discretionary power. But people who are specially trained to do that sort of work, why should there be guidelines? Does it mean that the law or the Constitution requires that in any situation of a discretion, a statute must give guidelines?
No, that's not what we submit. What we submit is this, where this power is given to these to police officers, guidelines are required, because the power ineluctably will affect the constitutional rights of the people in the area to be cordoned off. This court in Dawood said that where you have relatively junior officials who are vested with discretions, which may or may not interfere with constitutional rights, the statute under which they're exercised has to at least set out guidelines for the exercise of those discretions. Now, if what is being put to me is that it is appropriate to have a statute that says the police may on their own volition cordon off a substantial area containing perhaps thousands of people in order to restore public order, in order to achieve an object not decided on in the legislation, but decided on by a police officer, and may do anything necessary to achieve that object, the scope for abuse of police power in that instance is staggering. In fact, such a statute would potentially provide for a wider range of abuses than the applicants have been subjected to in this case.
But Mr. Wilson, the object is in section 13.7a. You are given twin objects. They come from the section itself. I don't understand why now.
With respect, not Justice Jafta. Section 13.7a sets out two broad purposes of the statute. It says, restore public order or to ensure the safety of the public. Those are the broad objects. Those are the broad purposes of the statute. But then the police commissioner has a discretion to set out within that rubric what object, how that object is to be achieved, how those purposes are to be achieved by specifying an object in the notice. Then on the statute as put to me, the police would have further discretion to decide in particular cases how the object, which the statute itself doesn't specify, is to be achieved.
No, but can the police commissioner decide on a purpose other than the two?
No, he definitely can't do that. But what he can do, what he is given, is the discretion to make his own mind up about what is necessary in the circumstances to restore public order and ensure the safety of the public. We submit, my lord, we submit, Justice Jeffter, that these are substantial and far-reaching powers. I mean,
I understand. You see,
the state often says it wants to make us safe. The state often says it wants to restore public order, and it often does horrendous things in the promotion of that.
But if that happens, Mr. Wilson, the state would not be acting within the parameters of Section 13.7a. If that happens, your clients would be entitled to assert their rights. The issue that we're dealing with is whether or not at an interpretative level, can you say that Section 13.7a may be read disjunctively with Section 13.7c? And when you look closely at the two subsections, you find that they serve different purposes. And what was put to you was what is wrong then with looking at 13.7a differently or separately from 13.7c, because the objects of A could still be achieved without searches.
Section 13.7, textually, Section 13.7a and Section 13.7c can't be read disjunctively. They're part of the same power. The purpose of Section 13.7a is to authorize what is done in terms of Section 13.7c. There are two things authorized in terms of Section 13.7c. One is searches. Let's take the searches away. We're left with a power to cordon off. That, we submit, is an inchoate power that can never serve any purpose that has been properly tailored and specified in the section. Justice Madlanger put to me, well, then the purpose of the cordoning off operation is whatever the object specified in terms of sections 13.7a and b is. And I submitted to Justice Madlanger that makes the meaning of Section 13.7 much, much broader than it currently is, and raises rule of law questions about to what extent police officers, or anybody else for that matter, can be given such a broad discretion to cordon off an area and to do whatever is necessary to achieve an object decided on by a police commissioner in terms of Section 13.7. So the way that this relates to the interpretive argument is this. If one is going to sever the searches from Section 13.7c and leave Section 13.7a and b intact, one must then come to a constitutional interpretation of what will be left. And what I'm submitting to the court is that there is no such constitutional interpretation of what will be left. What is left is an inchoate power to cordon off to no particular object. And then Justice Madlanger said, well, no, it's to the object specified in terms of Section 13.7b. Well, the problem there is that you've got one police officer saying what the object is, and another police officer without any guidance in the amended section deciding how to achieve that object. We respectfully submit that couldn't be a constitutional situation where there are large numbers of police officers going across a large area of the country, policing several thousand people under this extraordinary power that seems to impose no guidelines whatsoever.
Excuse me, Mr. Wilson. Can't you cordon off to ensure the safety of the public and restore public order as set out in?
Yeah, yes. So our submission is not that you can't do that. Our submission is that a power that simply allows for that and doesn't say what steps a police officer should take in order to achieve the object of ensuring the safety of the public or restoring public order would be inchoate. That's the first submission. The second submission is that it would be unconstitutional. We've thought a great deal about the difficulty that the court is putting to us. We absolutely accept the difficulty that the court is putting to us. Isn't it okay for a police officer or for a police commissioner to say there's a threat to the safety of the public, there's a threat to public order, and we need to do something about it? And I'm going to issue an authorization to cordon off an area and allow my police officers to do something about it. That may be an appropriate constitutional power. It might not be. It depends how the power will be implemented by the ordinary police officers concerned. We submit with respect that is primarily a question for the legislature. So what we want to do in this case is not do away with police powers to ensure the safety of the public or to restore public order. It's to strike down a section of the Police Services Act which is manifestly not able to achieve that purpose in a constitutional manner, and to ask Parliament to redraw the lines of the statute if possible. So there may be an appropriate constitutional power that allowed a police commissioner to issue an authorization to restore public order or to ensure the safety of the public, that granted specific powers to the police to do just that. But that's not what this section is. This section says restore public order and ensure the safety of the public. And when you are doing that, if you think it's necessary and reasonable, you can conduct warrantless searches. That's exactly how the applicants got into this mess. Massive discretions given over thousands of people to invade rights, to humiliate people, to search homes. So it's the discretion. The discretion is the problem, that the power to do all of the things, not just to search people, but to do all of the other things that might be allowed in a cordoning off operation is inappropriate, unless, of course, it's circumscribed. Now, what we're suggesting is that if you strike out the warrantless searches in Section 13C, it wouldn't be circumscribed.
Mr. Wilson, I just want to find out whether at the practical level,
yes,
you could have police exercising their powers in terms of A and B to the exclusion of C. Or you can bring that in line with the facts of this case. Could the police have gone to the prisons and decided to cordon off the area and just sit there and do nothing? And then if they are asked what they are doing, and they would say, we are here to restore order, public order, and ensure the safety of the public. I'm talking now at the practical level, whether it's that practicable or feasible.
Well, it sounds like an odd thing to do, quite frankly. If one wants to restore the safety of the public, one doesn't just sit around and do nothing, one does something. One doesn't just seal areas off. One must do something else within the area. And that's why we say Section 1370 is really about warrantless searches, because it's the only operative provision. But practically speaking, Justice Mutawalpo, no. The possibility of that happening just seems unrealistic, because we know that the police won't just do that. Also, the specter of the police cordoning off areas in this way is itself potentially abusive and intimidatory, unless there is a series of powers that they can then exercise for the public good. So, I mean, Justice Mutawalpo, the short answer to your question is it just sounds like a very odd thing to do. It sounds like an inchoate power, because that's what it is.
Mr. Wilson.
Mr. Wilson,
So your response to my brother Matopo is that it has never happened and it cannot happen that when police are asked to try and restore public order and ensure public safety, that they cordon off an area and then stand there. It has never happened.
Well, there's always some, well, no, I'm not saying that. There's always something else that's happening. And there's something else that's happening in section 13.7.11, for example, is that there's a crime being investigated. There may well be a cordon off operation.
If you take my example of crowd control,
yes.
Let's take my example of crowd control.
Yes. Yeah, and then there are
You're saying that there's always something happening. What would be happening?
Well, what would be happening in that case is the protest would also be governed by the Regulation of Gatherings Act. So whatever the police could do in relation to the cordoning off operation would be controlled in terms of that act. But a general power to cordon off to no particular purpose we submit is inappropriate. It always has to be cordoned off to do something else. That's the submission we make. We don't say that cordoning off operations are never appropriate. We say cordoning off operations always have to trigger some other form of police action. And for that reason, they have to be regulated. That's the submission. We don't say the police can't cordon off an area. They must just do it for a particular purpose, and what they can then do in the cordoned off area must be the subject of regulation. And to sever the warrantless search provisions of section 13.7c would leave the police with the power to cordon off an area and do nothing in particular inside it. Then the question becomes, well, one has to interpret the section to allow them to do something inside it, otherwise the power is worthless. And that's where we got into the debate with Justice Mdlange. He said, well, to ensure the safety of the public. Well, that's got to be subject to some sort of restriction, because sending the police into a large area to ensure the safety of the public doesn't always end very well, unless the police are subject to a series of statutory constraints.
Mr. Wilson, let me take you to the issues you raised when you were debating with Justice Jafta.
Yes.
The horrendous conduct that is likely to take place if the police have paragraph A power, unbounded as it were, if it is not subject to what C provides. If we do not agree with you on the dominoes effect type argument that you are presenting to us, and we say A and B can actually stand all on their own, what would you say must happen to A and B if we don't agree with you on your interpretation? In particular, in the light of the fact that there is no challenge based on the overbreadth type arguments that you presented in response to Justice Jafta.
Well, if the proposition is that section 13.7a and b can be severed from section 13.7c, then
I'm not saying so. I'm saying in the event that when we sit and determine the matter, we do not agree with your interpretation. Yeah.
I understand the point. The remedy is simply to confirm the order of the High Court on constitutional invalidity, and to refuse the application to vary that order. I would submit that at the textual level, though, that simply can't be done for a further reason, and that is that the authorization to cordon off in section 13.7a can't be implemented except by the exercise of a power in terms of section 13.7c. So if one reads section 13.7a, there's an authorization to cordon off. Then section 13.7c says, upon receipt of the authorization referred to in paragraph A, any member may cordon off the area concerned or part thereof, full stop. You still need that. If you think that it's okay for the police to cordon off an area and no guidance is then required about what they do, then you would have to sever everything from the words or part thereof in section 13.7c. So you sever the search powers. If you severed the whole of section 13.7c, then section 13.7a would be an inchoate power. It would be the power to issue an authorization, but there would be no other power on an ordinary police. An ordinary police officer wouldn't be endowed with the power to do anything about it. So on what you put to me, Justice Madlanger, we would submit that it's not just a question of cutting off C from A and B. You'd have to preserve a little bit of C as well. You'd have to preserve everything before the words or part thereof. And then everything from and may, where it is reasonably necessary, would then be severed. As to what then happens to our case, we'd submit that we'd still been substantially successful, precisely because the basis on which the Constitutional Court would confirm section 13, the invalidity of section 13.7c, would be a basis substantially different from the basis on which section 13.7c was declared unconstitutional by the High Court. So we would submit that if you were to preserve sections 13.7a, b, and I say a little bit of c in order to make those powers operative, then we haven't wasted our time here. The applicants have still been substantially successful. We have significantly widened the basis on which the judgment of the High Court was made. I see no purpose in repeating any of the submissions I've made about why you shouldn't do that. But we rest on those submissions, and we would, let me just say this, and it may be a rhetorical point, but I'm going to make it anyway. In the history of this country, law and everybody, and I don't want to lecture all members of the court who know more about the history of this country than I do, but I want to emphasize it. The unguided exercise of police powers has led to a series of disasters, both before the end of apartheid and after the end of apartheid. It's led to untold suffering and death. Section 13.7 as it stands is at least a clear power to do something. That something is unconstitutional. If the remedy that is put to me by Justice Jafta, Justice Madlanger, some members of the court, is adopted, it will broaden the police powers significantly in a way that I just think historically is inappropriate. Far better, we submit, to strike the whole section down and send it to Parliament for proper remedial action. And that's what we say. And I say that in all humility and with all respect, because it's inappropriate. It may be inappropriate for junior counsel to seek to give this court a lesson about what the police have done in the past. We all know it. And I respectfully round off my submissions on the constitutionality of section 13.7 on that note. We've examined the text of section 13.7. I haven't run into too much headwind about the failure to justify the warrantless searches under section 13.7. We simply submit that the searches under section 13.7 clearly can't be justified. The only justifications that have been offered by the police are that crime is bad and there's a lot of it about. The other justification, in fairness, that has been offered is that the that the Section 13.7 powers makes the police more effective. Now, this is the Section 13.7 power with the right to search. And we say, well, first of all, for reasons that I've already rehearsed, simply because something makes the police more effective doesn't mean it's a good thing or that it's a sound public purpose. The second point we make is that isn't true. I've already debated at length the meaning of Section 13.11 of the Police Services Act in relation to cordoning off. But even if we just look at the effectiveness of searches, Section 22 of the Criminal Procedure Act, the terms of which this court will be very familiar, provide for warrantless searches where they're needed in order to further the investigation of a crime. It seems to me that if you have a real worry about whether a crime is being committed or evidence might be destroyed, there's nothing in Section 13.7 that isn't granted in Section 22 of the Criminal Procedure Act. Section 22 of the Criminal Procedure Act is simply a narrower power to seize items where you would get a warrant, but actually getting a warrant would defeat the purpose of the search. So even at the level of conducting searches, there's nothing in Section 13.7 that makes the police more efficient or effective than they could be made for a legitimate purpose in terms of Section 22 of the Criminal Procedure Act.
Mr. Wilson, where there has been an authorization and the area has been cordoned off, can the police seek to justify warrantless searches on the basis of Section 22 of the Criminal Procedure Act?
Not at the level at which the cordoning off operation is conducted. So if there has been a cordoning off operation and then Section 22 of the Criminal Procedure Act is engaged in a specific instance, then the justification for the search would not be in terms of Section 13.7, be in terms of Section 22.
So they can still invoke Section 22, even though the context is that of a cordoning off done in terms of Section 13.7.
That we accept that would certainly be possible, Justice Jafta. We submit that a cordoning off operation that invites wide-ranging searches to no particular effect in terms of Section 22 of the Criminal Procedure Act is an unhappy case of Frankenstein legislation. Two different pieces of legislation meant to achieve two different things, but being read together in order to achieve a purpose which we've already said is in this case, has been quite destructive. So we submit that that's one of the reasons why an undefined cordoning off power would be potentially deleterious, because it would invite police commissioners to cordon off under Section 13.7 for the purposes of a criminal investigation, when that's not what Section 13.7 is supposed to be about. Because they would know, well, if I cordon off in terms of Section 13.7, I can say I'm doing it for the purposes of public safety, and then we can exercise our powers under Section 22 of the Criminal Procedure Act.
I just wanted to check whether there would be a gap in circumstances where the conditions laid down in Section 22 of the Criminal Procedure Act are met, whether the police would be hamstrung to act. But from the answer that you have given me, it seems that won't be the position. But here we're dealing with a justification based on Section 13.7.
And I'm perhaps revisiting a point in order to drive my previous submissions home. But I think the court will obviously make its own decision, but I think it's actually quite a good point that if one has a section 13.7 power that isn't clearly circumscribed to say, well, this isn't about criminal investigations, this is about public order, then one risks the bleeding of criminal investigation powers into public order situations. Now, one accepts that sometimes there's an overlap. But we submit that that overlap has to be governed by legislation precisely because of the constitutional rights at play. And the legislation has to specify appropriately how that overlap is to be managed. But in response to your question, Justice Jafta, there wouldn't be a gap, that's correct. A brief submission on retrospectivity before I move on to the interdict. We have said in our heads of argument that we really have no skin in the game as far as retrospectivity is concerned because the authorizations under which we researched have been reviewed and set aside. It struck me that that was perhaps an unhelpful submission. So I want to make a more helpful submission. And the more helpful submission is that if you should confirm the order of invalidity on any level, or extend the order of invalidity in any of the ways that we've suggested that you should, then we can find no consideration in this case that would trump the considerations set out by Justice Cameron in paragraph 49 of the Estate Agency Affairs Board case. It effectively said, if you retrospectively declare warrantless search provisions unconstitutional, you bring into question the integrity of criminal proceedings that have long since been closed. And so one ought to limit the retrospectivity of the declaration. I can find nothing in this case that would warrant a different approach. And those are our submissions on retrospectivity. So, Chief Justice, the second issue before the court is whether the High Court was right to refuse an interdict. The High Court found, obviously, that the applicants had fulfilled all the common law requirements for one.
Mr. Wilson,
yes.
Mr. Wilson, if we are with you on the section 13.7c, whether we sever that section, why should we grant an interdict? Because the interdict, if I understand you correctly, is to restrain the police from searching and inspecting any person. And if the warrant is no longer there, why is the interdict needed?
Yes, thank you, Justice Mplanta. The reason is because the interdict is broader than the Police Services Act, and it's broader than just the police. So you will have noticed from the record, Justice Mplanta, that this wasn't just a police operation. It was an operation conducted by the Department of Home Affairs and the City of Johannesburg. So we want interdicts against a whole range of respondents who participated in the searches. And the interdict is not just sought in relation to searches under section 13.7 of the Police Services Act. It's sought in relation to all searches that are unlawful and that do not meet the requirements set out in the interdict. You will notice that there are at least 2 searches, possibly 3 out of the 20 that we complain about, where section 13.7 was not engaged at all. The police just marched in. In the 7th applicant's case, it was the Johannesburg Metropolitan Police Department, and it was immigration officials, or a particular immigration official, who just marched in and decided that they were going to conduct a search. In another case, there was a search by the police. I think it was the 11th applicants. There was another case where there was a search by the police, and no authorization in terms of section 13.7 was produced. There was a still further case, and I think this was the 10th applicants, I'm not entirely sure, where there was a section 13.7 authorization, but the search was conducted outside the time limit set in the authorization. So our case goes much further than the engagement of section 13.7 of the Police Services Act. What happened here, and we're beyond the terms of the Act now, what happened here was not a problem, was not just a problem with section 13.7 of the Police Services Act. It was a coordinated effort in which Section 13.7 was engaged to achieve an improper and unlawful purpose. We know that in all of the cases of the searches, the police and the city have said, we're going to be back. Sometimes they say, we're going to evict you. Sometimes they say, we're going to search you again. The former mayor of Johannesburg boasted fairly significantly about what he'd done to the media. The former minister of police issued a press release saying, we're going to intensify this, this is going to go on. So in those circumstances, yes, Justice Trump.
Would the granting of the interdictory relief sought by the applicants not create a situation in which the applicants or future residents on those premises could act with a degree of impunity?
No, because the interdict is only to these applicants, not to the future residents. Secondly, the scope of the interdict is appropriately narrow. It's to constrain warrantless searches, unlawful arrests. I'll just go to the
what if
asked for in the heads of
some of those applicants were engaging in unlawful activity? Would the interdict not then protect them?
No. The respondents, this is the relief we asked for, Justice Strong. The respondents are interdicted and restrained from raiding, searching, inspecting, seizing any person or any item from or otherwise interfering with the applicant's peaceful and undisturbed possession of their homes, except, and this is where the abuse point comes in, except on the authority of a court order, a warrant granted by a magistrate or judge in terms of any applicable law, or in terms of Section 22 of the Criminal Procedure Act. That's the interdict we see. And so further abuse would be met with the exercise of powers that the state has, not with the exercise of powers that the state doesn't have. And that's really, we've tailored the interdict in order to cater precisely for that concern, Justice Turon. So there's nothing in the relief that we see that suggests that we should be immune from a court order requiring us to behave in a way that is lawful and appropriate. Nothing in the relief we seek that requires that would give us immunity from a warranted search, a search authorized by a warrant. Nothing in the relief we seek that would insulate us from section.
Why should there be an interdict stipulating what powers the police ordinarily may have in terms of legislation?
Well, there's an interdict restraining the powers they don't have in terms of legislation. That's the point. We don't seek to legislate. We don't seek to say the police can't do what they're lawfully empowered to do. We set out what has been unlawfully done in this case. We set out what is threatened to be done again in this case, and we say, please interdict that. The other lawful powers that may be exercised, the obtaining a warrant, getting a court order, Section 22 of the Criminal Procedure Act is fine.
If this court was inclined to grant an order rendering the powers under Section 13.7c subject to the same as those in the Criminal Procedure Act, would this not be an effective alternate remedy without the need for an interdict?
Well, that's what kind of what the High Court did. But are you suggesting, Justice Turon, that the Section 13.7 as it stands must simply be declared to read subject to Section 13 to the Criminal Procedure Act?
Well, like you say, a similar exercise to that undertaken by the High Court, but further subject to the powers, for example, in Section 22 or in further relevant sections of the Criminal Procedure Act?
Well, there are two problems there, Justice Turon. The first is that we don't just seek an interdict against the police. The second problem is that we don't just seek an interdict to restrain powers exercised under Section 13.7. And the third problem is simply this: Section 22, or the warrant, the search provisions of the Criminal Procedure Act, and the provisions of Section 13.7 simply can't be reconciled. So if one says, well, as they stand, so if one says, exercise your Section 13.7 powers consonantly with what is in the Criminal Procedure Act, an ordinary police officer who has to implement this might well say, well, how do I do that? Criminal Procedure Act says warrantless searches only in the circumstances set out in Section 22. Section 13.7 says I can perform a warrantless search whenever I think it's necessary to do what the police commissioner has told me I must do. So simply at that level, saying read one statute as subject to another would give us very little relief. In fact, it would broaden, with respect, the difficulties in interpreting what the police can and can't do in situations of this nature. But we emphasize this wasn't just the police, it was all the other respondents. And we need an interdict against them from unlawful interference. And we know also that the interferences took place not just for the police's purposes. There was an attempt as the High Court found to circumvent the Immigration Act. There was an attempt to audit the occupants of these buildings by the city of Johannesburg. It's not disputed before you that all of those purposes and all of those operations were unlawful, and that it is threatened that they'll be done again in the humiliating manner that we set out. So we submit that an interdict has a substantial use and a substantial purpose in this case. It's effectively to tell the city, the Department for Home Affairs chiefly, and the police that you can't carry out these operations in this way again. So that would go to the third requirement of an interdict, Justice Theron, that what the High Court did wasn't another effective remedy, because it was an interim interdict and not a final one, because it will lapse as soon as Section 13.7 is amended under the High Court's order, and because it will, and because the applicant's case goes broader than the police and Section 13.7. We've argued at some length in our heads of argument about the circumstances under which a court can decline to grant an interdict where the requirements have otherwise been met. The submission is that the High Court didn't find that our rights hadn't been violated. It obviously didn't find that we hadn't met all the requirements of an interdict. It exercised a discretion to refuse to grant one. So the High Court didn't say, in response to Justice Theron's question, that there was another effective remedy. It said, no, there isn't another effective remedy, but in any event, we're not going to give you an interdict. And that's the level at which we've pitched our case, because we accept and we agree with the High Court's conclusion that we met all the requirements for an interdict. We don't accept that there was then a discretion in this case to decline to grant one.
My understanding, sorry, Mr. Wilson, my understanding of the High Court was that it said because there's an interim order that it proposed to grant, it was not necessary to grant the interdict.
Yes, and that's quite difficult, because that seems to imply that the applicants had another effective remedy, and the High Court had already found that we didn't have another effective remedy. But leaving that tension aside, the problem with the interim order are problems we've already adverted to. First of all, it's interim and not final. Secondly, it only applies effectively to raids carried out under Section 13.7 of the Police Services Act, whereas the relief we seek is broader. And in effect, even though it isn't limited in this way, it only really applies to the exercise of police powers, where we're wanting to restrain the exercise of the City of Johannesburg and the Department of Home Affairs powers as well. So the interim order doesn't serve us just as well for all of those reasons. And it's obviously not the final interdict to which the High Court accepted that we'd proven an entitlement. A further problem is that the interdict was based on an order of invalidity that was itself too narrow. So the difficulty is this: when this court interferes, as we submit it must, with the declaration of invalidity that the High Court made, that will necessarily interfere with the scope of the interim interdict the High Court granted and the justification for it. So if you vary the order in any respect of constitutional invalidity, then you must face the question of whether or not the interdict, the interim order provided by the High Court, is still effective. So you're going to have to change it in some respect, unless, of course, you simply confirm what the High Court did. We submit the appropriate changes simply to grant us the final interdict. And I've already made the point that the interdict does nothing to help the 7th and 11th applicants. So as things stand now, there's at least the 7th and 11th applicants have no interdictory protection whatsoever. And that was another error committed by the High Court when it found, Justice Mfandla, that the interim order that it handed down would have suited us just as well. If I can then turn to our final set of submissions on constitutional damages. We submit that there are really only two questions. The first is, was there a breach of constitutional rights? And the second is, are constitutional damages, in this case, appropriate relief for that breach? Now, the first question has already been answered. There's no dispute that there was a breach of the rights to privacy and dignity. The High Court found it, the respondents don't challenge it. And this finding was in respect of each and every one of the applicants. It's important to emphasize now for the submissions I shall make later on about the High Court's finding that on the facts we weren't entitled to an interdict. That's irreconcilable with on the facts we weren't entitled to constitutional damages. That's irreconcilable with the proposition that on the facts our rights to privacy and dignity, each and every one of our rights to privacy and dignity was breached. The only real question is, yes.
I'm sorry. Which part of the judgment of the High Court will one find the finding that you have just referred to?
That our rights have been breached.
Of all. Of all.
Well, it's certainly in the order.
Not in the judgment.
From memory, it is paragraphs 99, 1 and 100. Oh, paragraph 104. And if I can just read Justice Jafter, it might assist the court. The undisputed facts demonstrate an egregious abuse of, an infringement of, the undisputed facts demonstrate an egregious abuse of, an infringement of the applicant's constitutional rights to privacy and dignity. In the circumstances, we are disposed to the view that the applicants are entitled to a declaratory order, that the searches, seizures, fingerprinting, and arrests conducted in the applicants' homes during the period of 30th of June 2017 and 3 May 2018 unjustifiably infringed their rights to dignity and privacy as protected by sections 10 and 14 of the Constitution. Now, I accept if what is being put to me is that it doesn't say each and every one of the applicants in that paragraph. I accept it doesn't say that, but it's impossible to conclude otherwise. The applicants are individually named on the record. Their names appear in a substantial list that appears between volumes 1 and 2 of the record. Those applicants were identified before the High Court. And the finding was made in respect of them. So there can be no suggestion that the finding is an abstract one in relation to a globular group of applicants. It's in relation to the people who were identified.
As I understand it, and correct me if I'm wrong, as I understand it, the High Court said on the facts, there are buildings where the whole floor was not searched.
Yes. Well, there was one building.
Now,
sorry,
would the applicants who lived on the floor that was not searched be entitled to constitutional damages as well?
No, Justice Jafta. We've accepted that part of the High Court's reasoning. So the High Court says there are two buildings. One where the police, we only seek damages against the Minister of Police. And there was one search of the 7th applicant's homes where the Minister of Police wasn't involved. And so we accept that we can't claim damages in respect from the Minister of Police in respect of the 7th applicants. There was another building, I believe it was the 11th applicants, but I speak subject to correction, where that building was searched twice. And on one of the two occasions, only the first floor was searched. Now we accept that on the occasion that only the first floor was searched, there's no way of knowing on these papers which of the applicants were searched and which weren't. On that basis, we accept that in respect of that search, an order for constitutional damages cannot follow. There was, of course, another search of that building where everybody was searched on the common cause facts, and constitutional damages must, of course, follow. We submit in those cases. And if I can take you, yes.
Perhaps while you're on that, we could look at paragraphs 116 and 117 of the High Court judgment, page 1070 at volume 10.
Yes.
And the findings that were made by the High Court.
Yes.
There is no primary evidence from each of the approximately 3,000 applicants in relation to the search of their homes and the manner in which they were treated by the police during the search.
Yes.
Then if we look at paragraph 117, it says what we know, only one or two floors were searched, yet all the residents that occupy the building at the time are claiming constitutional damages from the Minister of Police.
Yes.
Further down, line 24, we are not told which members of the third applicants occupy the first floor, yet constitutional damages are sought in respect to each of the 102 applicants who resided there. The 7th applicants, the papers reveal that their homes are not raided by the police, but rather by JMPD and officials from the Department of Home Affairs.
Yes. Yes. So, Justice Turan, we accept that the 7th applicants are not entitled to constitutional damages. We accept that in respect of the 14th of July raid, the 3rd applicants are not entitled to constitutional damages for the reasons given by the High Court. It is undisputed, however, that all of the people listed as applicants in this case, on all of the other occasions alleged by the applicants that the searches took place, were so searched. And so what we say in response to this is that it was no reason to decline the award of constitutional damages to everybody. It was a reason we accept to decline an award of constitutional damages to the 7th applicants and to the 3rd applicants on the particular incident referred to in the judgment. And the relief we seek at paragraph 6 of the order we seek in our heads of argument on page 49 of our heads is that the first respondent is directed to pay 1,000 rand to each of the applicants, save for the 7th applicants, for every unlawful search to which that particular applicant was subjected, as damages under section 38 of the Constitution, for breach of each of the applicants' rights to privacy and dignity caused by the raids of their homes between the 30th of June 2017 and the 3rd of May 2018. And then there's another qualification, save for the raid on the 3rd applicant's homes of the 14th of July 2017. Now, it may or may not make a difference for me to say that I argued this case in the High Court, and that difficulty was not put to me in argument. And if the difficulty had been put to me in argument, my response would have been the same as the one I've just given to the court here. Of course, there isn't a factual nexus in those narrow respects. But there is a factual nexus between each of the applicants and an unlawful search established in the papers in respect of all of the other applicants. The other point that the High Court makes, Justice Turon, is that the facts have been pleaded at a level of abstraction that makes it inappropriate to award constitutional damages. There are really two answers to that submission. The first is that the facts, the constitutional damages are sought for a breach of constitutional rights. The level of pleading required is one to establish that constitutional rights have been breached. Other facts may then be relevant to the appropriateness of relief. But one cannot say on these papers that a breach has not been established. The High Court accepted that there was one. So that's the first answer. The second answer is this: what the High Court seemed to require was personal knowledge of the manner in which the raids were carried out in respect of each of the individual applicants concerned. So what the High Court referred to the fact that there are some buildings where there are large numbers of people, multiple floors, and somebody standing on the bottom floor won't know what's going on the third or fourth floor. That's correct, but it ignores the manner in which the raids were actually carried out. As we say in our founding papers, and again, this is undisputed, the manner in which the raids were carried out was that everybody was pulled out of the building. They were on the streets, and the searches took place in the building while they were outside. I'm very sorry, Chief Justice. My internet connection just failed, but I think I'm back now.
Mr. Wilson,
yes.
Mr. Wilson, I'm sorry, on the quantification of the damages, did everybody of the 3,000 applicants sustain the same level of damage?
They did, in that they were searched unlawfully, and their right to dignity and privacy was breached. So the level of damages that we claim are the ones that arise on the facts set out in the founding affidavit. So the facts set out in the founding affidavit, I don't know to what extent I was able to complete this submission before the internet thwarted me.
Okay.
But the facts set out in the founding affidavit are that we were hauled out of our homes, we were made to wait on the streets, and then our possessions were rifled through, and the search was carried out. And then we went back in and we realized that we'd been searched. That is the fact that's been established in respect of each and every one of the applicants. We know that some applicants suffered worse. We know that some of them were assaulted. We know that some of them had their money stolen. We know that some of them had their doors broken down. But those are not the basis on which constitutional damages is claimed. We don't rely on those facts. The facts we rely on are the facts of the unlawful searches in themselves. The fact that we were hauled out of our homes, made to stand outside while the police went in and invaded them. That's the essence of the breach. That breach has been established in respect of each of the applicants. And that breach was the same in respect of each of the applicants. We know that there are some applicants who were treated particularly egregiously, and theoretically they may be able to claim a higher level of damage, but that's not our case. Our case is that everybody has at least sustained harm that would justify an award of 1,000 Rand per search.
And the amount of 1,000 Rand per search, how is it arrived at?
Well, the amount is what the Supreme Court of Appeal in Ngomani called a solatium or a token amount to recognize the breach of rights. The breach we seek, we don't seek relief in this case for pecuniary loss. We seek relief for a breach of, we seek a solatium for a breach of the right to dignity and privacy. And it's that kind of claim, the one that the Supreme Court of Appeal set out in Ngomani, that we make. We say that the damages are appropriate relief because they will be communicative. And so that has also influenced the level at which the quantum was set. If we wanted to punish the minister, or if we wanted to achieve some other severe purpose, we would have set our damages higher, and we would have said, well, you know, you've got to basically bankrupt the Minister of Police before he'll get the message. That's not what we're trying to say, and of course we haven't done that. What we want is a small token that says, yes, your rights were violated, yes, it was wrong, and the world at large is sent the message that this will not happen again. Now, other forms of relief we accept sometimes have that purpose. But we say that the breaches in this case were so systematic and egregious that a further, more extensive form of relief is appropriate. And that's really our case on constitutional damage.
Mr. Wilson, a last question from me on constitutional damages. In paragraph 8 of FOSI, this court said that common law remedies, particularly delictual remedies, have been designed to protect personality interests such as dignity. In cases where the harm arising from a rights violation is highly localized, a common law remedy may well be appropriate, and it may effectively vindicate the Constitution and deter further violations of it. Would we be able to apply FOSI in this matter, or do we distinguish it?
Justice Saron, that's precisely the case we rely on. We rely on the distinction drawn in FOSI between individualized violations of rights, where the facts are very discrete and sometimes quite elaborate in a particular case, and systemic violations of rights, which require a public moral response. And that is the distinction that runs through the FOSI case. The problem with the FOSI case is that it was an attempt by somebody who had already got some measure of constitutional damages to argue that, that some greater punitive category of damages was appropriate based on the Constitution. That is not our case here. It's also the difficulty the Supreme Court of Appeal had in Kamapi, where it was able to find a common law entitlement to damages. It said, well, that we're not going to award you constitutional damages in that case because the Supreme Court of Appeal found that they weren't available for non-financial loss. We submit that's wrong. They're available for systematic and severe breaches of rights. And so we respectfully nail our colors to the FOSI mast. We say that distinction that you set out, Justice Tron, is precisely the one we rely on. And we're on the systemic and severe, not the individual and elaborate side of that distinction. And for that reason, constitutional damages ought to be granted in this case. This case is really on fours with a case like Carty versus the Minister of Social Development in the Eastern Cape, where there was no financial loss. The interest that Ms. Carty would otherwise have earned on the money that she would have been awarded had the department done its job was used to calculate the quantum of damages. But Justice Nugent accepted in that case that she wouldn't have had that interest if the department had done its job, because the money would have been spent. Ms. Carty was a very poor poor people don't generally accumulate interest on assets. They spend their income. And so that's why we say there's a tension between the Kamapi decision and the Kati decision. The Kati decision actually suggests that where there's a systemic breach of rights or a systematic breach of rights, constitutional damages are appropriate to recognize and communicate the lack of acceptability of that breach. We accept that it can only be in the most egregious cases where the communicative function of damages needs to be performed. But we submit that if that function doesn't need to be served in this case, there will rarely, if ever, be another case in which it does. Chief Justice, with your leave, those are our submissions for now.
Thank you, Mr. Stewart. Mr. Mpaha.
Thanks, Chief Justice. Chief Justice, in respect of section 13.7a, b, and c, we submit that section 13.17a and b, quite clearly, there is no basis at all for an order of unconstitutionality to be made against these two subsections.
Let me just try to remember. Did you say you were willing to be interrupted from the beginning, or did you ask for 10 minutes? I don't seem to recall what your request was.
We said 30 minutes, Chief Justice.
No interruption at the beginning. Are you ready to be interrupted, or should we give you some time to make your submission without interruption?
I'm ready to be interrupted, Chief Justice.
Thank you. You may proceed.
Chief, I agree with the sentiments expressed by the Justices Madlanga and others in respect of the interpretation of section 13a and b, and we don't see any reason why it should be disturbed in any way. And we have made common cause with the finding of unconstitutionality in respect of 13.7c. And in that respect, we submit that it was important that the reading in by the court ACO should make it clear in respect of making sure that 13.7c does not condone warrantless search of homes. And in that respect, we have made common cause, and the respondents agreeable that the court ACO was correct in making that finding. So we would submit that it would not be in accordance with justice to have 13.17.7a and b to be disturbed, and they should be left as they are, because they serve an important purpose in respect of making sure that the respondents, the police, complies with section 205 of the Constitution in respect of prevention and combating of crime. And we therefore submit that if one interferes with that, what you are taking away the discretion of the commissioner or the provincial commissioner, and it is not the purposes of the courts to second guess administrators in respect of the administrator, like the National Commission and Provincial Commission.
But Mr. Wilson, Mr. Mpaha says without C, the rest of subsection 7 is hollowed out. What's your response to that? Or on what basis do you say it is not hollowed out?
It is not hollowed out because if you look at 7a, for instance, it makes provision that you can have a cordon off without a necessity to search. So meaning that you can have a cordon off to restore public order and safety and ensure safety of the public without any search. If, for instance, there is a protest, you can be able to cordon off to make sure that traffic is not disturbed and people are not injured in respect of the traffic or any conduct that may happen at the protest. So you may be able to have 7a without necessarily invoking the issue in respect of the searches as per 13.7c. So we submit that for 7a and b to be declared unconstitutional, quite clearly it did not serve any purpose at all in respect of giving the police a discretion to decide upon themselves when it would be necessary for them to cordon off or not. And Chief Justice, if
I understood. Just sorry, Mr. Mpa. I understood Mr. Wilson also to rely on a Hande type interpretation that says if we say A can survive the invalidation of B, that renders the section even more susceptible to police abuse, and that therefore a better interpretation, or one that better accords with he didn't refer to Hande, but one that would better accord with a Hande type interpretation is the one he is advocating. What's your response to that?
My response, Justice Madlanga, is that his argument is predicated on the basis that police are there to simply not to comply with the law. And I don't think that is the basis. That it would seem as if that we may even go as far as to say that police will always we will always have unlawful searches and unlawful arrests. Those will always happen, but it doesn't mean that police who comply with the law should be barred from being able to protect it by or exercising a discretion in terms of 13.7. So the whole issue in response to that is meaning that constant training of the police to make sure that they comply and they do not abuse their powers. So we cannot really legislate to make sure that police won't abuse their powers. It happens every day. That's why we have so many cases where there are warrantless searches, which are necessary. There are unlawful arrests. So those ones we cannot really legislate. It will depend on continuous training to make sure that the police, in exercise their discretion, they comply with the law and the Constitution. So that would be my submission. And therefore, we would submit that 13.7 AC, as Mr. Wilson says, that it is not so that the warrantless search in respect of search of persons, premises, and vehicles should be also declared unconstitutional. We submit that if one looks at the reading in by the court accord, it makes it clear that Section 22 of the Criminal Procedure Act should be invoked in respect of C to make sure that the Criminal Procedure Act applies. And when you do that, then it is quite apparent that any search which is unauthorized in terms of Section 28 of the Criminal Procedure Act would be an offense. Therefore, if you invoke 22 in 13.7C, then it will be clear that police cannot abuse their powers, because Section 28 of the Criminal Procedure Act says that it will be unlawful, a punishable offense, if you abuse the authority. So we submit that we subscribe to what the reading in of the court accord has invoked, and we submit that if that reading in remains, then there won't be any issue to continue any further to in respect of 13.7C. So we
Mr.
submit
Mpaha,
that.
Excuse me, Mr. Mpaha.
Yes, Justice.
The reading in of the one that was done by the High Court only refers to, it excludes the private home or person inside from the warrantless search.
It is so.
It doesn't deal with the other items like the vehicle, the receptacle. And if you look at Section 14 of the Constitution, is there, what do you say about that?
Justice, the most important thing when I read Section C, when it says, and may where it is reasonably necessary in order to achieve the object specified, it means that the police officer who is exercising those powers in respect of search must form an opinion at that time whether the search of a person or an object is necessary. It is for that reason that the purpose of that search, it should be to seize an article referred to in Section 20 of the Criminal Procedure Act. In other words, in itself, there is a limitation there. It is not broad. It must be for that purpose that Section 20 prescribes of the Criminal Procedure Act. It means that Section 22 of the Criminal Procedure Act will still apply, where there has to be consent by the person who's been searched consent by the owner of the motor vehicle. Would submit that if we have any other interpretation, it would make it difficult for the police to combat or prevent crime. And we submit that in respect of the reading in, clearly by excluding warrants, searches against persons and vehicles, in that way, it gives the police still to have the discretion. So the whole purpose is that police, in exercising their discretion, they should do so, as I indicated, with the conviction of what the Section 22 of the Criminal Procedure Act prescribes. And if they comply with 22, then in that case, there won't be any problem.
Mr. Mpaka, I'm not clear what your submission is regarding the discretion that must be exercised by the police officer in relation to Section 22. Please, can you repeat your submission for me?
Section 22, if I read it, it says that if there is consent from a person who is being searched, then there is no necessity for a search warrant in that respect. So in regard to persons who may be in the cordoned off area, then the police may continue with the search if there is consent from the person who is being searched, from the driver of the motor vehicle that is being searched, and therefore there won't be a necessity for a warrant in those respects.
Yes, I would like to take you back to the question posed by my sister, Justice Mhlantla, because I'm also very interested in your answer, Mr. Mpaka. And if I recall correctly, the question directed you to the reading in that was done by the High Court, and that this only carved out an exception in relation to the home or the private residence of the person that's being searched. It does not cover the premises, a vehicle, and my sister also directed you to Section 14 of the Constitution, which says that everybody has the right to privacy. And the question related to the application of Section 14 and the reading in by the High Court. And whether that reading in, which only carves out an exception for the private residence, doesn't amount to an unjustified limitation of the right to privacy in Section 14.
Thank you, Justice. It is so that if one reads 14, then one has to say that whether 13.7 is it a legislation of a general application which may limit those rights in Section 14 of the Constitution. And I would submit that 13.7a should be read with Section 22 of the Criminal Procedure Act. It can be read in isolation, and would submit then the limitation of the rights in Section 14 can only be justified when searches are done on persons and vehicles where people are giving their consent. So in cases where consent is being refused, then it may be necessary that a warrant of search should be obtained. So I'm reading 13.7.
Do I understand you correctly to say that you don't agree with the reading in by the High Court, that it doesn't adequately protect the right to privacy? Or am I misunderstanding you?
No, yes, I agree with the reading in, because part and parcel of the main complaint of the applicants in the court ACO related mainly in respect of the searches of their private homes. It was never an issue in respect of searches in respect of persons and or vehicles, because the applicants were not speaking about vehicles, because they were only talking about the fact that they were removed from their private homes, which were searched. So the issue was mainly, the complaint was about searches in private homes. And
but Mr. Mpaka, the applicants are challenged the entire Section 13.7 and in part even 7C. They may have said something about their homes, but their challenge was related to the entire section, that is 13.7.
Yes, Justice Mhlanga, if I may.
Before you respond to that, just to add on to it, some of the evidence that was presented was that the applicants were taken out of their homes and their person was searched outside of their homes. That was part of the complaints of some of the applicants.
Justice, if I may respond to that, I might just say that my argument in respect of 13.7c, my argument is that the provincial commissioner or national commissioner does not have a right to instruct policemen to search. The power to search comes from section 20, 22, 21, and so on. So therefore, when the section C says, and may, without a warrant, search, that power must come from section 22 or section 23. It cannot be a power that is given by the provincial commissioner because it does not have that power. So therefore, when it says may, it means that the police officer who's doing the search must form an opinion at that time. It's similar to a policeman who is conducting an arrest. He cannot say, the commissioner said, I must go arrest. At the time when he arrives, he must form an opinion whether facts that are before him justifies an arrest. Same here, the policeman, even if he has this authorization, when he does the search, he must form an opinion whether the facts before him justifies a search. Therefore, you cannot read 13.7c without looking at the Criminal Procedure Act. And I would agree with the suggestion made by the justices to the effect that it may be that part and parcel of the reading in must make the provisions of the section 22 and so on applicable to the whole section. That may be able to give clarity in respect of the section in itself. And I would submit, that was my submissions in that respect. I don't think, justices, if the 22 is made to, the searches in terms of persons and vehicles are also linked to 22. That would be harmful to the 13.7c. In actual fact, in my submission, the reading in by the High Court was simply to make it clear to the reader of Section 13.7c that warrantless searches cannot be condoned. Those would be my submissions in that respect. Then if I may then move justices to the whole question of retrospectivity, I agree with my learned colleague that the High Court was correct to say that the finding of invalidity of Section 13.7c cannot be retrospective in itself. And the interdict, the issue of the interdict, I would submit that the High Court exercised a discretion. And from the arguments of my learned colleague, it is not that the High Court does not have the discretion at all. The high level of his argument is that that discretion is limited. But quite clearly, there was justification that was made by the High Court on why the interdict, even if they met all the requirements, cannot be granted in the circumstances. And we'll submit that quite clearly, you have an interdict which applies to a number of residents, and an interdict which is final. What if those residents are no longer there tomorrow, or some of them would have relocated anyway? So we would submit that it would be superfluous for the court to grant an interdict in those circumstances, and we submit that the discretion of the High Court was properly exercised in the circumstances. And the fact of the matter is they have the inherent discretion in granting an order that is just and equitable. And if they did so, the honorable justices cannot necessarily interfere with that discretion. And we submit that they were correct in doing so. And lastly, in respect of compensation, we would—
I'm sorry, Mr. Mpacha, I'm sorry.
I'm moving too fast.
Yes, I understood the High Court to say the reason why they were not willing to grant the interdict was the interim relief, the reading in the interim relief that they have granted. So Mr. Wilson says that is wrong. because that reading in only covers the police. It doesn't extend to the Department of Home Affairs. It doesn't extend to the city of Joburg. Yet, the city of Joburg and Home Affairs were some of the respondents against whom the interdict was sought. What is your submission to that?
Thanks, Jay. I think the answer to that also is that to give an interdict wherein you are simply saying that the police must not act, or the city of Joburg must not act outside of the law, I think in itself is superfluous, because we expect the police to respect the law. So it would be quite untenable for the court to then give an interdict that would in any event make sure that the residents are not exposed to the abuse of power. There are remedies which they can exercise in respect of making sure that those abuses don't happen.
Like what?
Like
we know, for example, here that there were egregious violation of rights. The level of unlawfulness on the part of officials, the police, the city, and Home Affairs was very high. And these people were subjected to this unlawful conduct over a period of time. So what sort of remedy would be there?
We would submit that a remedy that would be applicable is simply that there can be, as I indicated in terms of Section 28 of the Section 28 of the Criminal Procedure Act, there can be it is an offense for one to abuse the powers of search. There's compensation, there are damages that can be given, and it's also the person who abuses those powers can be found guilty of an offense. So there are remedies that can be applicable. And we submit that it not be necessary for, as we speak, there's never been any repetition of what happened before. And we submit that by giving this judgment in itself has ensured that there is no repetition or continuous repetition of that conduct.
No, but Mr. Wilson says there was not only one search. There were a number of them. So I don't understand the submission that says there was no repetition.
No, from the time
with threats, Mr. Mpaka, that we're coming back.
Yeah.
And there's never been a coming back, and from the time when the judgment was granted. And I'm saying the judgment in itself was a deterrent to ensure that there's no repetition of what happened before. And we submit, therefore, that we even made those undertakings in court as we argue in this matter, that it won't happen again. It will happen in accordance with the law. So we'd submit that we'd expect policemen, we'd expect the JMPD and everybody, the Home Affairs, to comply with the law. And mostly, this JMPD, these operations which happened, they happen on the basis of Section 13(7). So basically, it never happens that you will have Home Affairs and JMPD only having an operation by themselves. So once we have dealt with the question in respect of 13(7)(c to make sure that it is aligned, to make sure that it complies with the law, then I do not see any fear that there can be any repetition of what Mr. Wilson is complaining about.
We are testing whether or not the discretion was exercised properly by the High Court. If we find that the reason given by the High Court indicates a misdirection on its part, because Mr. Wilson says, look at the reason is limited to a section of the respondents. It doesn't cover all respondents. If we find then that that reason, which is advanced by the High Court, indicates some misdirection, won't we be entitled to interfere with the exercise of discretion by the High Court?
I think insofar as it relates to the Home Affairs and JMPD, But I think the reading in itself, insofar as the respondents, the police is concerned, I submit that the discretion was exercised correctly in that respect. But what is of importance is that these authorizations, when they are granted, one would be able to see that it also lists the agencies or the law enforcement agencies that are involved, including the Home Affairs. So they are all incorporated in the authorization. But that is why I'm saying that the High Court may have then looked at the authorization and realized that this police and the JMPD all acted in one concert. So insofar as you may find that they were supposed to at least include the JMPD and Home Affairs, I would submit that your lordships would be correct in looking into that. So if I may then, the last one in terms of the compensation, we would submit that the Kotako really applied its mind in considering this and in exercising its discretion. It was able to find that Ngomane was distinguishable from the facts of this case. If one looks at Ngomane quite clearly, it was not only about interference with the right of privacy and so on, but there were damages of goods and housing material and so on that the applicants there lost. And that insofar as, and it looked into the whole issue of for them to go and claim damages for what they have lost, it will really be an exercise which will be costly, and therefore the award of damages was found to be appropriate. In this matter, it is only one or two individuals who complain about having lost money or having lost some items, but all of them, they never complained about the fact that they have lost articles. So if we submit that if one looks at Ngomane and other cases, there is a linkage between the pecuniary loss of some sort by the applicants, and not only limited to the violation of the right of privacy and so on. So
what
we
about,
submit.
Mr. Mpaha, what about the violation of their dignity? One of the claimants, for instance, was compelled to undress or dress in the presence of a police officer. Some of the residents, their goods were thrown out and were damaged in the process. So why would they not be entitled to constitutional damages?
Would submit that, as I indicated, that those are what happened here, as Justice Jafta has said. There hasn't been a proper computation as to who. Is it one or two individuals? Now you have about 3,000 claimants here, and only a few of them who are even not mentioned properly alleges that their properties were damaged and so on. So we submit that the High Court was correct in saying that there are no primary facts that are put before them in respect of what actually were the damages and so on. We submit that in this respect, it is not a case that can compare with Ngomane in other cases. It is a case where clearly one would speculate. And it is what Justice Theron has said, that it's a matter where the common law damages could have been pursued, where individual claimants would have come to court and said, this is what we have lost and it costs so much. So we submit
is the short point you're making, Mr. Mpaha, that the damages that are not patrimonial can never be claimed by way of constitutional damages? Is that the short point you are making?
That's the short point I'm making.
And why is that?
There has to be.
Why is that?
I would submit that there has to be some patrimonial loss of some sort that pertains to the breaches of privacy or dignity. And in such instances as in Ngomane's case, also in the matter relating to SASSA pensions, where clearly one can be able to see that the failure by SASSA in making sure that payments are made on time has a pecuniary loss in some way. And we submit that although in an egregious violation of rights, maybe the court in its discretion could be able to consider it. But here where you have an exercise of a discretion by the High Court, who submit that the Honourable Court, justice must be slow to interfere with their consideration in respect of the facts of the
Sorry,
case.
Mr. Mapaka, can I ask you this? To have 3,000 people stand outside the building, approximately 3,000, while their rights to dignity and privacy are breached, why is that patrimonial? Is that not a pure constitutional breach?
It is a constitutional breach. I'm just arguing the point that it is not only the issue, the constitutional breach must also, in my view, lead to some pecuniary loss on the part of
but
the
it's a solatium. It's a solatium for the breach of the dignity and privacy.
Yeah, in
Why
granting
must there be a patrimonial loss?
In granting the solatium, the consideration should also not necessarily be limited to the fact that there has been a breach of privacy and dignity, but also consider the pecuniary loss that that breach would have caused. In other words, when the searches went ahead, money or property was lost, damages, and there has to be replacements, like in the Gomani cases, these things must be replaced. And for them to go to court,
that's patrimonial loss. This is a constitutional breach.
I'm just saying that the
proving loss of a fridge or a broken glass or whatever, that is something different from a pure breach of a constitutional right to dignity and privacy.
Justice, I was just arguing it on that basis that there has to be some interlink between those breaches and some suffering of some pecuniary loss. Those will be my argument, that my submissions in that respect.
So you want them to claim, to institute a intellectual claim against the police and prove their losses. That's what you say.
Yeah, I think what Fosse said, that I mean their common law rights are still intact, and I also say that if you look at section also 28 of the Criminal Procedure Act, it makes provision for compensation in respect of damages. So would submit that in circumstances where there is another remedy that can be able, like the people who says they've lost money, people who says they've lost property, and how do you then be able to give all of them the same amount when other people have lost more than others?
Excuse me. The section that you're referring to in the Criminal Procedure Act, it may or it may not be of assistance. Remember, on the facts of this case, the applicants went to the police station to open cases and they were turned away. And if on your submission and you want to place reliance on the section in the Criminal Procedure Act, that is tantamount to denying them a remedy. In fact, as I understand the argument of the applicants, it's not about patrimonial loss. It's about what my sister Victor has put to you. And what I want to establish from you is, that being the case, are you saying that their remedy would lie elsewhere, not in the constitutional damages?
No, I'm saying the constitutional damages remedy should also take into account. In other words, the court in considering constitutional remedies, it would also have to consider other facts, including whether there were any related damages that have occurred, like in the Ngomane case, where the court also take into account that the violation did not only end in breaches of the right to dignity and the right to privacy, but it went also...
Well, excuse me, sorry to interrupt you. If a claimant or an applicant says, I was hauled outside my home for a period of X number of hours, and my right to dignity has been infringed, and on that basis, I want to know if, because of that, do I have any relief, any remedy that I may seek against the police officers? Despite having lost anything at all, I want to know, how can my feelings have been injured. How can my feelings now be addressed? What do we say to that claimant?
Meaning that his property was searched unlawfully.
Property was searched and he was made to wait outside, and he says, I feel that my constitutional right to privacy and dignity were infringed. And he says, I'm here and I want to know how can I vindicate those rights? Are you going to say that person must be sent to the higher court or to the small claims court?
No, I don't think that it takes away your discretion of the court to consider whether to grant constitutional damages or not. I think the court will be well in its right based on the facts before it to can consider granting the compensation. And I would submit that in this respect, the High Court considered the facts before it, and I would submit that it applied its own discretion. And it cannot be said that that discretion was applied in a manner that was inconsiderate to the rights of the applicants. I would submit that they exercise their discretion in terms of Section 172. I admit the fact that compensation can be granted in respect of violation of privacy and right to dignity without there being any criminal laws. But it is a discretion of the court. And in this respect, I would submit that on the facts of this case, the High Court exercises discretion in a manner that accorded with the facts before it. Those would be my submissions. We necessarily don't ask for costs, and we say that insofar as the justices may find against us that there should not be any order of costs, because in any event, an organ of state in matters like this must be there to make sure that it assists the court in respect of, especially in respect of the confirmation of an order of validity. So we have to be here to be heard.
But why must the applicants be out of pocket then?
We are just saying that we had to be here to advance, not only in respect of the...
I understand that, but effectively the applicants would then be out of pocket. Why must they be?
I'm not so sure whether they will be out of pocket, Justice Magala, in noting that they are an NGO of some sort. So I'll submit that. I'll leave it in your discretion. Insofar as your concerned.
Mr. Mpaga, was it not the Minister of Police who championed the passing of the impugned legislation in Parliament?
It is so.
So the applicant had to go to court to have it declared invalid. They had to come here to see to it that the order of invalidity is confirmed. Why would the minister not be responsible for costs, for their costs?
Yes. No, Justice Jafta, I leave it in the hands of the court. I don't want to take it any further than that.
You tried, Mr. Mpaga.
I tried to save the state some costs. Thank you.
Thank you, Mr. Mpaga. Mr. Wilson.
Thank you, Chief Justice. I have, by my calculation, 6 points in reply. The first relates to the proper interpretation of Section 13(7) of the Police Services Act. My learned friend gave an example of the possible use of the Act to control traffic in the event that a protest got out of hand. There are two answers to that submission. The first is that traffic control is something that is dealt with extensively in Section 13(8) of the Police Services Act. The power to cordon off or block a road, and indeed to conduct warrantless searches in those circumstances, is authorized in terms of Section 13(8). So if you were to strike down Section 13(7), you certainly wouldn't be depriving the police of the power to control traffic. There are also other aspects of the Police Services Act that deal with the Metro police officers' abilities to deal with traffic. And there is the Road Traffic Act, which deals with what one can do in circumstances where there is a road traffic problem. The second point goes to how you choose to interpret. The police will never comply with the so to suggest that it would be appropriate I'm sorry.
Are you there, Wilson?
I was again thwarted by the internet. Hopefully I won't be at risk for much longer.
Mr. Wilson, will you start your second point again, please?
I'll start my second point again. We don't say, no part of our argument is based on the proposition that the police can never be trusted to do anything without violating anybody's rights. Our argument is that the police must be governed, the police power must be appropriately controlled and regulated. And the number of regulations and guidelines must increase as the exercise of that power approaches a horizon across which are constitutional rights. Now, we submit that Section 13.7, as it stands, crosses that horizon. And we submit that simply...
Why can't we proceed on the assumption that whatever they do is subject to the provisions of the Constitution? Why should we itemize the manner in which they should execute that responsibility? The Constitution is there. Shouldn't we assume that they know that they are supposed to have regard to the constitutional rights of the people that they are going to interact with?
Well, there are two answers to that question, Chief Justice. The first is that that's not what this court has said in the past. In Dawood, and it was made very clear that where a statute gives a power and the exercise of that power involves a discretion, and the exercise of that discretion may intrude upon constitutional rights, the statute must delineate. The legislative drafter can't simply assume that the bureaucrat or the officer in question will have the Constitution in their hearts and will understand exactly what it means.
Let's interrogate that. Let's interrogate that. Why must we delineate?
Well, we submit you shouldn't delineate.
It's always open to us to overturn our previous decisions. So let's have that engagement. Why must we delineate?
Well, on the first point is, please don't overturn Dawood. We're very happy with it. It's a good decision, and if you want further submissions, we'll give them to you.
It's not a question of you being happy or unhappy. Just tell me, why should we be specific? Why should we itemize them? Let's just put Dawood aside.
The second submission is this. We don't expect the court to itemize. We expect the court to require the legislature to itemize.
No, that's obvious. That's what you require. That should be done, to be done to the legislation. That's obvious. Why?
Because if you give the police
I can't hear you, Mr. Wilson.
The host has stopped my video, Chief Justice.
All right.
Mr. Wilson, please will you proceed? We may hear you better with the video switched off.
Okay, I'm very happy to proceed behind a curtain. Let me start the submission again. Where a statute gives the police a power to cordon off an area and to conduct a special operation in that area, then the purpose for which that operation can be conducted and the tools with which that operation may be implemented ought to be specified in the legislation. To do otherwise would be to create an intolerable risk of a breach of fundamental rights, having regard to the nature of the power, the police power that is being exercised. Now, in this case, what we have is a statute that says the police can cordon off in order to ensure public safety or to maintain public order. Then there are two discretions provided. The first is that the police commissioner must specify an object, and the that the police in the furtherance.
You disappeared again, Mr. Wilson.
Please proceed, Mr. Wilson. Chief Justice would appear. Oh, yeah. Please proceed, Mr. Wilson.
Thank you, Justice Turon. In section 13.7, there are two discretions. The first is that the police commissioner may exercise his discretion to decide what object further the section 13.7 purpose. And then an ordinary police officer may exercise the discretion to decide whether a warrant of search is appropriate in a particular case. We say that because the section 13.7c authorizes warrantless searches, it should be declared constitutional. But we also say what would then be left is a broad discretion to cordon off an area to conduct a wide range of operations which could interfere with constitutional rights, and no guidance in the legislation to set out when that discretion can be exercised. And that is the respect in which we say that the Wood principle, that the legislation needs to specify with more particularity what kinds of objects can be pursued and what kinds of tools can be used to pursue those objects. And
for example,
well,
let me, Mr. Wilson, I'm putting this question to you to try and see whether what you are proposing would not have the unintended effect of unduly limiting the police in combating crime. You itemize, there's a list. A reasonable need arises when they are there to do something as they can't because it doesn't fall within the list that you proposed.
Well,
so give me an example.
Well, the first answer to that question, Chief Justice, is the entire debate today has taken place on the basis that Section 13.7 is not about combating crime. It's about ensuring public safety and ensuring public order. The police have the police have the Criminal Procedure Act. No part of that act is challenged in this case, and to unduly impede the police in the investigation of crime is not the object of the applicants in this case. The police, we know, weren't investigating crime, not really in this case. Crime was
what is the list?
So the question is, where a statute provides the police with some other power beyond the police power to ensure public safety, to ensure public order, beyond the power to investigate crimes, the statute must delineate the circumstances under which that power can be exercised and the tools.
I'm sorry, Mr. Wilson. You've said that. I'm just trying to.
Yes,
I'm basically asking you to be more practical. Give us some guidance here, so that one can have a sense that you are not asking of something that you yourself have not even thought out.
Yes. If I'm repeating myself, Chief Justice, I'm sorry. I'm just not sure how much with this connection that you've heard. But just to go at the practical level, all we ask this court to do is to recognize that sections 13.7a, b, and c serve a set of interlinked purposes in a specific non-criminal investigatory set of circumstances. I don't ask this court to perform surgery on the legislation and to start setting out the conditions under which the section 13.7a power can be exercised. I accept that the section 13.7a power may, under some circumstances, be constitutional. What we have is a statute that sets out the exercise of the power in a manner that is unconstitutional. So practically, what we suggest is that section 13.7a be struck down in its entirety and the matter referred to the to Parliament to redraft the legislation. In the interim, what then happens is that the police have both the section 22 power to warrantlessly search if those conditions are met, and the police have the power under section 13.11, which, although it doesn't explicitly talk about non-criminal investigation, would serve all of the purposes that have been put to me by the court. Because in order to ensure the safety of the public, in a situation of protest, for example, where there's violence or damage to property, that section 13.11 must be triggered because there's a reasonable suspicion that a crime might have been committed. So that's the interim situation we would encourage should be adopted, the interim attitude that should be adopted. But there could, of course, be a role for the police in preserving public safety and preserving public order, which is not anything to do with the exercise of criminal investigatory powers. This court shouldn't say anything about that. It should tell Parliament to consider whether that is the case and to redraft the legislation. It would be dangerous, we submit, to leave the legislation hobbling along without the power to search, but with a broad, unspecified power to do a lot else in a cordoned off area. The second submission we make in reply is linked to the first, and that is this. The police clearly see this as a criminal statute and not as a criminal statute, and not, sorry, Justice.
I'm sorry to interrupt you. Justice Jafta, we have momentarily lost the Chief Justice, and this is an aspect that he was particularly interested in. May I suggest that we take a short adjournment for perhaps 10 minutes while we try to reconnect with the Chief Justice?
Thank you, Justice.
Thank you, Justice Turon.
Yes, indeed, my sister. That's fine.
I hand over to the Clerk Registrar.
Court is adjourned. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences. Should you exit, please note that you may use the same link to join the hearing.
subscriber you have dialed is not.
Nine, 4, 6, 0, 0, 8, 4, 6, 3. Junaid, can you hear me?
Chief Justice, I can hear you.
Okay. Are my colleagues there?
Yes,
Yes, they are.
and we can hear you.
Colleagues, you won't see my face. I'm connecting with my phone, but I'm glad I'm connected now. There's a problem. My iPad doesn't reconnect.
Yes. Mr. Wilson, are you with us, Mr.
Wilson?
I'm here, Justice Taron. May I proceed?
Justice Taron, are all colleagues in?
I'm checking, Chief Justice.
Thank you.
Justice Victor has not joined us yet, Chief Justice.
Okay, please let me know when we're all in, my sister.
I will do so, Chief Justice.
Mr. Naidu, I just called Justice Victor. She says she's trying to get back on and that the host is not letting her back on.
Justice Madlanga, I can't see her in the lobby. However, I think she's on the call now on the phone. I'll just speak to her and then revert. Thank you.
I'm back, Chief Justice.
Oh, thank you, my sister. Justice Teron, are we all in?
Yes, Chief Justice, we are all online.
Thank you. Yes, over to you, Mr. Wilson.
Thank you, Chief Justice. I was just about to move on to my second point in reply. That point is simply this, that the police, and it was confirmed in my learned friend's submissions, clearly understand Section 13.7 as being a criminal statute, or as being a statute that allows them to investigate crime. The basis on which its constitutionality is being tested in this court, for the most part, is whether it confers powers that are of a non-criminal nature, of a public order or of a public safety nature. Now, we accept that there's always going to be some overlap, but the fact that the police defend the statute as a criminal investigation tool, in our submission, heightens the sensitivity this court should have to what will happen if all it does is sever the warrantless search provisions in Section 13.7c. It emphasizes the point that if the police are to be given public order and public safety powers, or if any form of public order or public safety power under Section 13.7 is to be preserved, it is absolutely essential that the legislature to delineate the line between the use of the cordoning off power for criminal purposes and the use of the cordoning off power for public order purposes, and how those two purposes tend to interact with each other. That's what we say is dangerous about simple 7A and B intact. The third submission is in response, and it's a very brief one, in response to my learned friend's point that our only complaint was about searches of our home. It was put to my learned friend that on the facts, the complaint went further than that. But in any event, as this court held in Ferreira versus Levine, the constitutional validity of Section 13.7 must be determined objectively. I'm sorry, I was momentarily disconnected.
Well, maybe while you are there, in circumstances where the section was clearly sought to be used for its real purpose, and in the course of doing that, a crime is seen to be committed, is it still open to the police to proceed and seek to nip that crime in the bud, or would another process have to be followed? In other words, are there such strict lines once the provisions of this section has been invoked that in circumstances where a police person would ordinarily be entitled to arrest or to do whatever to combat crime without a warrant, would it still be open to them to act and investigate or arrest in those premises? Or in the cordon off area?
Mr. Wilson, are you?
Justice Teron, I'm here. My connection appears to have failed again. My data connection appears to be very robust. I'm getting 50 megabits a second as we go. So I'm not quite sure what the technical problem might be. I shall try to soldier on and I'll see if I can abbreviate my submissions.
Okay. I won't interrupt you, Mr. Wilson.
Thank you, Chief Justice. I think the answer to your question, Chief Justice, is wherever those lines are, whether they're bright or complex, they should be drawn by the legislature. And the problem with the remedy that would only strike down Section 13.7c or the greater part of it is that those lines would be blurred even more than they are now. And there is an inherent conceptual problem with defending the constitutionality of the statute on the basis that it is a tool to investigate crime, and this court preserving the statute on the basis that it's really a public order and public safety statute. There needs to be some sort of determination, some sort of policy choice made about how those two purposes interact. If you simply sever Section 13.7c, you'll deny the legislature the opportunity to make that choice.
And I promise not to interrupt, but I am. And you would argue that it's not a question of being pedantic. It really is necessary to adopt that approach.
I'm relatively rarely accused of pedantry, and I think in this case, I don't think it's pedantic. It's really a three-tier question. What powers? The first tier is what powers can the police exercise in order to ensure public safety and to protect the public against threats to public order. The second tier of the question is what powers can the police exercise to investigate crime? The third tier of the question is how do the discretions that may or may not be granted to exercise the first two powers interact with constitutional rights? Those are classically legislative questions. And the problem is the effect of striking down even just that Section 13.7c reposes them to the legislature. If one leaves Section A and B intact, they hang in the wind, and they'll have to be sorted out through practice. And the practice, as we know in this case, is destructive to the rights of poor and vulnerable people. Whether the police intend it or not, that is the effect. The third submission is an answer to my learned friend's interpretation of Section 13.7c. What my learned friend appeared to submit was that the discretion to search or not search granted by Section 13.7c is one that has to be exercised with regard to Section 22 of the Criminal Procedure Act. The effect of this interpretation seems to be that Section 13.7c actually doesn't grant warrantless search powers at all. What it says is that if you want to conduct a warrantless search, consider whether Section 22 has been engaged of the Criminal Procedure Act. We submit respectfully that on the text, that's simply an untenable proposition. The Section 13.7 grants the power to search warrantlessly on the jurisdictional facts that it sets out, not the jurisdictional facts that any other legislation sets out. And again, we have this problem. If Section 13.7 is to be defended as a health and safety power and not a criminal investigation power, how at all could it ever be interpreted in light of Section 22 of the Criminal Procedure Act? Because the purpose of that power is the investigation of crime. So we submit that the interpretation advanced by my learned friend is simply untenable. It doesn't get out of the starting blocks. It's also, and I say this with respect to my learned friend, it's a submission with sinister consequences. Because if the submission is that actually what the police can do in terms of Section 13.7 is cordon off an area and then seek people's consent to search their homes, we would counsel the court against an outcome that would enable the police to do that, because the consent in those circumstances could never be free, voluntary, and informed as it's required to be. The police come into your building or come into your home. They stand in front of you and they say with a smile on their face, "Do you consent to a search?" Whatever you then do cannot really be consent or the withholding of consent. So there's another public policy problem with the cordoning off power and the exercise of criminal investigation powers. the cordoning off power could interfere with rights to consent or withhold consent that are given by the police powers. Now, where those lines are to be drawn, as I say, is for the legislature and not for this court. And that's why a striking down order is what we suggest is appropriate. Our next submission goes to the interdict submissions made by my learned friend. It was suggested that, that the applicant's case is not that the High Court used it inappropriately. That's not quite right. Our primary submission is that there can be certainly no common law discretion to decline to where there may be room for a discretion we submit is under section 38. Rights. But an interdict is not. Discretion to decline to grant a final interdict. I disappeared again for a moment. There is no common law discretion on which no common law basis on which a court can exercise a discretion to decline to grant a final interdict where the common law requirements have been met. Now, we submit in this case, for all the reasons I've given, and I shall not repeat, that it would be just and equitable, it would be appropriate to grant the interdict it would be just and equitable under the Constitution. It would be appropriate relief under Section 38 to grant the interdict, because that's what's necessary to effectively protect the applicant's rights in this case. So we say that the common law discretion doesn't really come into play. It's whether it's just and equitable or appropriate under the Constitution. And for the reasons I've given, it is both just and equitable and appropriate. A further submission made by my learned friend is that an interdict would be superfluous because the applicants move in and out of their homes. The first answer to that is, of course, if the applicant moves out, then the interdict no longer applies to them. We only seek an interdict in respect of the individually identified applicants in this case. But this, I'm constrained to notice, with respect to my learned friend, that there's a particular stereotype relied upon here of the applicants, that they are transient people who aren't entitled to the same remedies as everybody else. Now, if I wanted to restrain the police from coming into my home and I asked for an interdict, I would be extremely surprised if the answer came back, yes, you're entitled to an interdict, but you might one day move out, so we're not going to give it to you. Of course, no one would make that, I would assume that no one would make that assumption about an interdict I would apply for because I own my own home. These people don't own, the applicants don't own their own homes. And they're being treated they're being stereotyped by that submission in a manner that I respectfully submit as inappropriate. They are not transient people. They are human beings who have rights under the Constitution and to interdicts that everybody else has as well. My learned friend submitted that none of the searches took place with just Home Affairs and the JMPD being involved. That's respectfully just not true. The 7th applicant's homes were searched by only the JMPD and only Home Affairs. That's very, very clear on the record. And for that reason, the interdict is required in respect of them, in respect of Home Affairs and the JMPD. So my learned friend sought to resist the interdict on the basis that, well, really, it's the police that supervise and trigger these raids. And you don't need to worry too much about the applicant's submissions, that they also need interdicts against other people. Well, at least the 7th applicant's case negatives that submission. It is true, in fact, that there are some raids, or at least one raid, in which the police have not been involved. Before I reach the issue of costs, there is one final submission in relation to constitutional damages, and it is to simply re-emphasize the fact that our claim is not for patrimonial loss. It is for, as Justice Victor put it, a pure breach of constitutional rights. If one conceptualizes the claim in that way, then the factual problems raised by my learned friend and by the High Court simply melt away. The problem in this case, the burden of pleading in this case for the applicants was to show a set of facts from which an inference can be drawn that their rights were violated. And those facts were, as I think Justice Victor pointed out, the being torn out of your home, made to stand on the street, and then having your possessions rifled through. That's the breach, not an assault, not a humiliation, although all of those things happened. What we claim for is the breach of rights occasioned by the search. The other things happened, and the other things were horrible, but we accept that they didn't happen to everybody, and that the remedies in those particular cases need to be pursued in other ways. And finally, it goes back to what Justice Turon said about the Fosey case. Here, we're talking about a systemic breach of a large number of people's rights, not a particular case with its own eccentricity, not a particular case of one breach of one person under delict with its own factual and legal eccentricities. And that is the distinction that, with respect, Justice Turon pointed out, is made in Fosey. Constitutional damages may be appropriate in the case of systematic breaches of rights, where one set of facts leads to a conclusion that thousands of people's rights have been violated. They probably won't be appropriate in eccentric cases pleaded under delict. We're on the systematic side of that line. And once the true nature of the factual pleading of the constitutional breach is appreciated, then the High Court's judgment and the learned friend's arguments simply don't affect the applicant's case. On the question of costs, if we are substantially successful, we obviously seek the costs of 2 counsel against the Minister of Police. And obviously, if we're we at least ask you not to make a costs order against the applicant. The point was made to my learned friend that we had to come to court to get.
Mr. Wilson, are you with us? Is Mr. Wilson's Jr. with us?
There was a short interruption again there, Chief Justice. I don't know if I can now be heard.
You can be heard, Mr. Wilson.
There was a short interruption again there, Chief Justice. I don't know if I can now be heard.
No, you can be heard, Mr. Wilson. It looks like this technology is targeting you and I.
Yes, Chief Justice. Well, great minds are targeted alike, are they not? Chief Justice, members of the court, I am on the final leg of the final submission, so let me just make it. We did anticipate opposition from the city. In the High Court, that opposition came very late. So as a way to insulate ourselves against a last-minute set of heads from the city of Johannesburg, we asked for costs against the city as well. Of course, those heads didn't come. A notice to abide was filed, I think, less than a week ago. In those circumstances, we don't seek costs against the city of Johannesburg. We seek costs only against the first respondent, the Minister of Police, and those costs will be the costs of 2 counsel. Chief Justice, members of the court, unless there are further questions, those are our submissions.
Thank you, Mr. Wilson. Judgment is reserved and the court adjourns.
Today's proceedings have concluded. The host will now terminate the meeting.